All right, I want to welcome everybody to the second to last Courts of Justice Committee meeting before crossover. We have, I think, about 20 bills in the docket for today. No, maybe more than that. 2025. And let's see, we got to sign up here. I'm sorry. Clerk will call the roll.
Mr. Chair, you have a quorum.
Thank you, MJ. All right. First on the docket, we have Senator Sturdivant signed up. Senator Sturdivant. Your caucus isn't happy, Sturdivant.
Mr. Chairman,
Senate Bill 693.
Yep. Thank you, Mr. Chairman. The Simple Country Lawyers staff is good at getting down here quick and signing them up. 214 first, Mr. Chairman. Is that?
Yes, sir.
Pleasure. Mr. Chairman, Senate Bill 214 is a bill that would require a summons for garnishment against a corporation, LLC, limited partnership, financial institution, or other entity authorized to do business in the Commonwealth to be served on the garnishment designee, and that is something that is defined in the bill. And so, just like these entities have a registered agent, they would also have a garnishment designee, so that when you get a judgment against somebody and you need to enforce it, it's clear that there is an entity to be served, and there is a substitute, Mr. Chairman.
Okay. Senator Stewart moves. Senator Stanley seconds the substitute. Motion, we adopt a substitute. All those in favor say aye. Aye. Anybody opposed? Is the substitute already distributed to everybody?
Yes, Mr. Chair. Everyone should have a copy. And it'll be online shortly.
All right, 214. Let's pile here.
And Mr. Chairman, the substitute really just is technical changes. It notes that it's a financial institution as defined in 6.2-100. And in lines 61 and 62 just adds limited partnership and financial institution, which I think had been left out of the original draft. But that's the bill. It comes at the request of the Creditors Bar Association to help clean up the code here, and there is an expert witness to speak on the bill, Mr. Chairman.
So, Senator, just so I'm clear, are you getting rid of the ability to serve a lawsuit on an officer or designated employee of a corporation?
This is not about serving the lawsuit. This is about serving the garnishment summons after a judgment has been obtained, and it simply requires that these entities designate a garnishment designee so that it's easier for them to know who to serve on, just like to figure out who to serve a lawsuit on, go to the State Corporation Commission, figure out who the registered agent is. This would be a similar process for serving a garnishment summons, and the reason being is that way you don't have the sheriff or the private process server having to go to people's houses or having to go to their front office during business days when customers are there. They can go and serve it directly on the garnishment designee.
So, Senator, so is every corporation in the state going to have to update their record with the SEC to have an additional registered agent, a garnishment designee, going forward?
Mr. Chairman, members of the committee, Reese Wilkes on behalf of the Virginia Creditors Bar Association. Senator, to answer your question, this bill is really reorganizing what's already currently in the code, and this is dealing exclusively with garnishments. To answer the senator's question, there is already abilities to have a garnishment designee with the State Corporation Commission. This merely is readdressing who the next person down to serve would be if it so happens there isn't a garnished designee with the State Corporation Commission. The goal would be that the perfect situation is that you have a garnishment designee, but if it so happens there isn't one, the next step down would be either a registered agent or whomever the garnishee would designate to determine who would be served, as opposed to merely the way the law reads now, which is you've got to go down to a member, or you have to go down to whoever is going to be who is ever actually who would be sort of a business owner, and then the registered agent would sort of be the last in the line. So we're really just reorganizing what's already in the code.
So maybe I'm trying to understand why the creditors bar thinks this is better as opposed to the judgment paying bar. I mean, I would think you would want more people to serve and easier to serve rather than making it harder for you to serve people.
So the reason why the creditors bar is bringing this is part of a process, and it's sort of, since the creditors are obviously bringing garnishments before a court, this is part of there's a procedural process that one has to go through in order to determine who's the appropriate party to serve. Currently, right now, if you have a garnishment designee with the State Corporation Commission, it makes it very simplistic to serve that individual. But if it so happens that you don't have that garnishment designee, you start going down the current waterfall. That waterfall may be a managing member. It may be somebody who is a managing employee at the local bricks and mortar store. And then you would have, at the absolute last, would be your current registered agent. That registered agent also requires a due diligence process, and you have to sign a due diligence affidavit that you have followed certain steps in order to ensure that you have done everything else before serving the registered agent. This bill just simply it corrects a defect that the original law had already done. It just kind of moves it up and allows a little bit more flexibility of who you can serve.
Okay, Senator Peake, I think, sounds like he has a question.
Mr. Chair, witness, I mean, how many companies have a garnishment designee? I got to tell you, I represent tons of small companies who just have a single guy. They serve the owner. He turns it over to their treasurer. I mean, I've never seen a garnishment designee.
There has been the ability to designate a garnishment individual for this purpose. And again, we're merely talking garnishments. We're not talking for due process of any other reason, with the State Corporation Commission for a number of years. Now, if it so happens that the business is a mom and pop shop and they wouldn't have any reason to have any filings with the SEC, clearly they're not going to have a garnishment designee. So that would be other elements contained within the bill that would allow a creditor or a sheriff to be able to properly serve a garnishment designee, which would be sort of a mom and pop. It would be that individual who is a member. This is just merely giving a little bit more flexibility to the way the current law reads now.
Any other questions before we go to testimony or support? We've kind of had support, but Senator Sturman, you got anybody else in support?
I think this is it.
Huh? That's
Yes.
it?
Yeah.
Okay, is there anybody opposed to the bill?
Mr. Chair,
Senator Deeds.
I just want to understand, there aren't substantive changes to the law with this bill. You're just reorganizing things. Is that correct?
I'm sorry, Senator.
There aren't substantive changes to the law.
These are technical changes. This is not substantive.
Okay.
Okay. Where'd Sabrina go? There, she's over there. Mr. Benjamin. But if we were to pass this, you could no longer serve an officer of the company unless that person were the designee, right?
Mr. Chairman, I'm not the one to answer that.
Got it. Maybe Sabrina can answer that.
You can answer that.
Sabrina, my question Sabrina, my question is, if we pass this, you can no longer serve an officer of the company. You can unless that person has been made the garnishment designee at the SEC. Their SEC filing, right?
Sorry. Mr. Chair, give me one moment. So, Mr. Chair, just to clarify, the question is whether or not an officer, unless they are named the garnishment designee, could be served. Is that correct?
My question was, if we pass this, the only time you can serve an officer with a garnishment is if the company has filed a paper with the SEC stating that that specific officer is the garnishment designee. Otherwise, you cannot serve an officer of the corporation with a garnishment, right?
Mr. Chair, I believe that is partially correct. The next, so if you look at the substitute lines, 25, starting on line 25, if such garnishment designee is also the judgment debtor, they can be served either in accordance with various service provisions or a managing employee. And then if you look at the definition of managing employee on line 60, that can be an employee who's charged by the corporation or limited liability company, et cetera. So it would depend on, it depends, unfortunately, for the law school answer.
Okay, Sabrina, I think we've figured it out up here. All right, so I think you can serve an officer if you can't find the designee. If there is no designee and you can't find anybody else or something. Right?
All you have to do is check the state corporation.
All right. Okay. Any other questions from the committee? Is there a motion?
Second.
Okay, it's been moved and seconded. We report the bill. Clerk will open the roll.
It's switched up.
Subramania, legal proxy over there. No.
Ayes 12, noes 1, abstentions 1.
Okay, the bill reports 12 to 1 to 1. Senator Sturman, I think you have one more?
Yes, sir. 693, Mr. Chairman. I know we have all heard about the housing crisis. We're all aware of it. One of the things that I have heard repeatedly from the home building community, from the realtor community, is that this is a supply and a demand issue, and that we need more supply. And so one of the things that has been an acute problem on the supply side of housing has been over the last several years since the pandemic is these large financial institutions like hedge funds and private equity groups buying up single-family homes and oftentimes competing with average, everyday folks trying to buy a house with a mortgage. They can't pay all cash. They're on a budget, and they're bidding against a hedge fund that has no budget, can pay all cash, and can close in, the same day. And so that's what this bill seeks to do, Mr. Chairman, is to prohibit these large financial institutions like public equity funds, private equity funds, and hedge funds from skewing the housing market in Virginia by buying up these large numbers of single-family homes and taking them off the market. InsideInnova.com, just about a month ago, December 28th, there's an article that noted oftentimes the hedge fund can pay all cash to the sellers and quickly turn the property into a rental, leaving families out of luck. According to the Urban Institute, as of June 2022, large hedge funds owned around 574,000 single-family homes nationwide. And more recently, 27% of single-family homes sold during the first 3 months of 2023, so last year, were purchased by large financial groups. Almost 30% of all single-family homes sold during the first quarter of last year were purchased by large financial groups, not your average everyday home buyer. This is from WTOP News. In the fourth quarter of 2021, investors bought a record 18.4% of all homes in the U.S. And specific to Virginia, in that same time frame in the Washington, D.C. single-family home housing market, these hedge funds and private equity groups bought 8% of the single-family homes in Washington, D.C., and in the Virginia Beach metro area bought 9% of the single-family homes sold in that market. And this actually, a lot of this comes from a New York Times article that was done back in 2022, and it was referred to again in December of 2023, and that New York Times analysis story examined the impact of corporate-backed investment, and this was in Charlotte, North Carolina, where in 2022 investors bought 17% of the city's homes in cash, oftentimes outcompeting first-time home buyers who rely heavily on mortgages. And in one neighborhood, again, this is in Charlotte, but these investors bought half the homes in one neighborhood that sold in 2021 and 2022. And then more recent data, even as the housing market has slowed, in June 2023, so 6 or 7 months ago, investors bought 26% of the single-family homes sold in June 2023, according to this New York Times article.
Senator, so, by the way, I don't think you've put your finger on the fact that there's a problem, or at least from my point of view. I don't know how the committee feels, but I'm sick of getting all these phone calls asking me if I want to sell a house, which I get every day constantly, and there's no question the supply problem. I think most of the questions in the committee probably relate to the specifics. I think you have some amendments you wanted to make.
Yes, sir. There is a substitute.
Senator Stewart moves, Senator Peake seconds. Do we adopt substitute? All those in favor say aye. Aye. Anybody opposed? No. Adopt substitutes before us.
And the differences in the substitute from the original you may have seen online is that it originally used the single-family home definition and referred to it as an interest in residential land. We took out the reference to residential land. That was, I think, too confusing, and so it just refers to an interest in a single-family home. And then we, at the request of some of the folks who were interested in this bill, there was a reference, several references to prohibiting any agents, trustees, or fiduciaries of the hedge fund or private equity firm, and we took out that agent, trustee, and fiduciary thereof language.
So now Governor Youngkin can buy a house, but Carlisle can't.
We're not going to have perfect legislation, Mr. Chairman, but we're trying to address a real issue here.
Mr. Chairman.
Okay. Senator Stewart has a question.
I have a silly question from, when I first got elected here, we had bills with gray covers on them.
With what?
Gray covers that indicated the bills were not constitutional or there may be a constitutional issue. Can somebody explain to me how we can discriminate against two classes of buyers? I learned in law school that that was unlawful. And in fact, it probably would be void ab initio, but
You mean like
I'm just a dumb country lawyer.
you kind of. So I was about to say like Chinese land
No,
purchasers?
that would be different because
Okay,
they are adversaries of the Commonwealth and they're hostile to us. They want to kill us.
All right.
And we have a compelling state interest to protect our citizens from hostile foreign adversaries. Would you like me to go on, Mr. Chairman?
No, but Senator, I think Mr. Benjamin's run away for now. But Sabrina, do you have an opinion about his question about whether it's constitutional?
Push the fast forward on this.
Yeah.
And let it hit some.
Mr. Chair, this is something I'd probably have to look into a little bit more, unfortunately. I do not have an answer right now, but I can continue looking.
Okay, that's fine.
Mr.
Senator Deeds.
Chair, if the way I look at this, I mean, it depends on the prohibited actor in the language of the bill self-regulating to a certain extent by recording something. What if a commercial lender loans money for somebody who's later determined to be a prohibited party, and the party buys property? What happens to the commercial lender's lien?
Mr. Chairman, Senator Deeds, that was one of the things that was raised about 5 minutes ago was what happens to the title to the property after it's determined that a prohibited entity can't have it. And I think as was dealt with in the agricultural land bill last year, and I think would need to be an amendment to this, is that it would revert to the Commonwealth to then be divested of.
Senator Peake, you got a question?
Mr. Chair, yes, just from the viewpoint of a big city lawyer, every law is constitutional until a court tells you that it's not constitutional.
Thank you, the senator from the big city. From the big city. Okay. Senator, before we take testimony, anything else you want to say? Any other questions to the patron? No? Okay. Why don't we set this at like 3 and 3, MJ? Is there anybody in favor of the bill that'd like to come up?
If there's anyone online that would like to speak in favor, raise your hand.
Okay. Nope, doesn't look like there's anybody. Okay, is there anybody opposed to the bill? Come on up.
If there's anyone online that would like to speak in opposition, please raise your hand.
Thank you, Mr. Chair. Erin Corman with the Realtors, and we do oppose this bill. Just at the top level, there is no way for an agent or a seller to figure out if the person bringing them a contract is a prohibited business. And the bill language does not take into account what would happen if a seller, unbeknownst to them, sold to a prohibited business. But once we look a little bit deeper, we still have significant concerns. The bill says that corporations that currently own have to divest their interest by January 2025. And I apologize if that's changed in the substitute. I haven't seen it. But this assumes that there are buyers out there for all of these properties. The more likely outcome is that these corporations are going to sell these homes for less than market value or sign them over to the bank and just write off the losses. And these forced sales or deeds in lieu of foreclosure are going to negatively affect the property values of other people in the community. The bill also doesn't take into consideration that the corporations are often buying up vacant, blighted, derelict homes that there are not home buyers lined up to purchase, nor could they even get financing for these homes. And they are going in and fixing them and making them livable for someone else. So for those reasons, we do oppose the bill, and I'll pass my time to people behind me. Thank you.
Mr. Chairman, members of the committee, James Pickrell with the Virginia Land Title Association. I'd like to thank the patron for being willing to work on this bill. I know the substitute is substantial. I know that he's willing to do more work, but we have remaining concerns about a possible break in the chain of title and would really like more time. And I'm hesitant to not oppose the bill until I can run it by my clients. Thank you.
Okay, thanks. Bankers.
Mr. Chairman, members of the committee, Matt Bruning with Virginia Bankers Association. Just want to associate my comments with those already articulated by the other folks in front of me. I think to Senator Deeds' point, that is a concern that we have. Again, this is we appreciate what the patron's done on trying to address some of it, but the talk about voiding transactions and the effect on the financing behind those and lien raises some concerns I'm not sure we can get addressed in the next 7 days as we move forward. So we ask you to we understand the issue probably requires a little bit more and lengthier time to examine the implications of that. Thank you.
Is anybody online opposed?
Mr. Chair, there's no one online to speak in opposition.
Okay.
Mr. Chairman.
Senator McDougall.
Mr. Chairman, I think that Senator Sturvant's brought a issue that concern a lot of people. At the same time, there's some concerns about making sure that we are doing some things constitutionally. And I realize I have some small country and some big city lawyers to my left. I'm just a good lawyer, and a good lawyer and a good lawyer would measure twice and cut once, and I think we need to measure one more time on this. So I'm going to move that we carry this bill over and send it to the Housing Study Commission to see what we can do to deal with this problem and not also infringe upon the constitutional rights of people to purchase property.
Senator Sturvant, is that you good with that?
Not really, but
not really, but
yeah. I mean, I think from some of the responses we've gotten that there are concerns raised, and understandably there are concerns. It's an indication of the extent that this is going on in the Commonwealth, and it is having a real impact on real people. And,
no, Senator, I think there's universal agreement. You're on to a problem here. I just think there's some questions up here around me about what the solution is. So I think you might get a solution if you go to the Housing Commission. We'll see. Yeah. Okay. Yep. Senator McDougall moves. Senator Stewart seconds that this bill go to the Housing. We PBI the bill with a letter from the chair to the Housing Commission to study it. I'm sorry, carry it over with a motion with a letter from the chair to study it. Clerk will open the roll. All right, I'll do that. I like the bill.
Ayes 15, no zero.
Thank you.
Okay, thank you, Senator. So next on my docket, I have Senator Locke, who I don't see, right? Oh, she is. Oh, you're behind three people's head. Okay, Senator Locke, you've got Senate Bill 23,
Bill
I think.
23.
Yeah.
And there's a technical amendment.
Mr. Chair, those have been distributed as well.
Technical, that's distributed.
Yes, and Mr. Chair, the technical amendment, it's just on line 371 of the bill, just strikes criminal offense and changes it to delinquent act. Since we're talking about juveniles and delinquent juveniles, that would be the language to use.
Right. Okay, Senator, why don't you explain to us what your bill does?
I will certainly do that, Mr. Chairman and members of the committee. Virginia currently does not have a minimum age for children to be adjudicated delinquent. Between 2019 and 2023, 228 children 10 years old or younger had delinquency complaints filed against them. The youngest was 6 years old, a kindergartner. As a result, children this young can also be arrested. In 2018, the American Legislative Exchange Council passed a resolution encouraging states to establish a minimum age of at least 10 before a child could be adjudicated delinquent. States like Texas, Mississippi, Louisiana, Arkansas, and Nebraska have all passed minimum age legislation whereby children under either 10 or 11 cannot be adjudicated delinquent. So what this bill does is specifies that a delinquent child is a child 11 years of age or older who has committed a delinquent act. Currently, there is no minimum age for a child to be adjudicated delinquent. The bill provides that if a juvenile younger than 11 years of age is found to have committed a delinquent act, the juvenile shall not be proceeded upon as delinquent. However, the court may make any orders of disposition authorized for a child in need of service or a child in need of supervision. And that's what the bill does.
Thank you. Senator Locke, does anybody have any questions for Senator Locke? Okay, no, we got to take testimony. Is there anybody in favor of the bill that would like to come up? That's why we said it 3 and 3.
If there's anyone online that would like to speak in favor of the bill, please raise your hand.
And you guys wanted me to cut off debate.
Hi, members of the committee. My name is Zoe Love Joseph. I am 9 years old, but my birthday is next week, so I'm basically 10 years old. I go to Mayberry Elementary School, and I am a member of Rise for Youth. Please pass Bill SB 23 that says kids cannot be charged with crimes if they are younger than 11 years old. Honestly, that's still way too young. I was really mad when I learned that kids younger than me have been charged with crimes. Kids my age should not be in court. If we get in trouble, we should get help from our family or any other people that care about us. I don't understand how chemical court works, and neither should other little kids in Virginia schools. My biggest worry should be learning in school, listening to my parents, and making sure my pulled teeth are underneath the pillow so the tooth fairy bends me my money. I'm speaking up for this bill for me, my sisters, and any other little kid in Virginia. So please don't let kids 10 years old or any younger go to criminal court. Please, and pass SB 23.
Thank you for listening.
Thank you for your testimony. You seem like you're older than 10 years old.
Good afternoon, Mr. Chair and members of the committee. My name is Teresa Kamenos, and I'm here from Human Rights for Kids. We are here in support of Senate Bill 23 because the establishment of a minimum age of prosecution is a human rights issue. There are many ways that our laws recognize that children are fundamentally different than adults and that their brains are not fully developed. And this bill is targeted at very young elementary school age children of 10 and younger. Children of this age do not have the capacity to form criminal intent or the ability to comprehend basic legal principles. And there are other more appropriate systems already in place through the Children in Need of Services or Supervision provisions of the law, which allow a court to order a broad range of services designed to support the child and family to address any behavioral concerns without criminalizing young children. It's also important to recognize that when we're talking about the children who become involved in the criminal justice system, we are talking about the most vulnerable children in our communities. Studies show that 90% of children in juvenile justice systems have experienced adverse childhood experiences. So we're talking about protecting the youngest and most vulnerable members of our communities. We've heard some concerns that reforms like this could lead to recruitment of younger children to commit crimes on behalf of adults through gang involvement. But this claim ignores the simple fact that if a child is recruited by an older individual or forced to commit a crime on someone else's behalf, then that child is a victim of human trafficking by forced criminality. A child in this situation is a victim and should be treated as such. Thank you.
Thank you. Do we have anybody online?
Mr. Chair,
sir,
we
you
have
too.
2 people online.
It's up to you. Say who you are and whether you support oppose the bill.
Maisie Osteen, attorney with the Legal Aid Justice Center, and we support the bill.
Got it. Anybody online?
Julie McConnell, you may unmute, and please make sure your camera's on.
Our time's expired. If you just say who you are, who you're with, and whether you support the bill. Yeah, we haven't taken opposition yet either, though. Okay. Is there anybody in opposition to the bill?
Mr. Chair, there's one more person that would like to speak.
In favor or opposition?
Tyee Mallory with the Virginia NAACP. We support the bill.
Okay, thank you. Opposition coming up. Reset the timer to 3.
If there's anyone online that would like to speak in opposition, please raise your hand.
Come on.
Good afternoon, Mr. Chairman, members of the committee. My name is James Toohey on behalf of the Department of Juvenile Justice. I must say it's a hard act to follow, coming on the heels of a very intelligent 9-year-old, but I'll do the best that I can. Virginia is among 24 states with no minimum statutory age of criminal responsibility. Of the 26 states that do have a statutory minimum age, it's important to note that 18 of those have an age that's lower than 11. Virginia relies on the common law, which establishes a presumption against the ability to form the requisite criminal intent for children under 7, and a rebuttable presumption against criminal responsibility for children between the ages of 7 and 14. In relying on these common law presumptions, the legislature appoints judges who are trusted to exercise their judgment in applying the common law presumptions after much thought and consideration based upon the youth and the facts and circumstances of each matter. In fiscal year 2019 to 2022, 77.7% of petitioned juvenile intake complaints for youth under 7 were dismissed or no prost. 16.3 were still in the process of being deferred or pending. 3.9% were guilty, and 1.8% were not guilty. Those who are adjudicated delinquent can be ordered to state services, and then the case can be dismissed and expunged. There are some funding issues that are at play here that I think warrant some consideration. And under CHINS, the funding streams are either the family's insurance or the family assessment and planning team for high-risk youth, to which funding is through the Children's Services Act. That's based upon a sliding scale. So, and parents who are indigent are able to get those services for I believe it's free. Parents who have their own insurance and are more wealthy are able to pay for it themselves. What happens is families who are on the lower income scale, who are not indigent, oftentimes can't pay for those types of services, and they're they're left in a void there. Also under the the Virginia Juvenile and Community Crime Control Act, different jurisdictions may vary on the services that they provide, parents who aren't indigent but don't have enough money for counseling services may not be able to receive the services for their child, assuming that the jurisdiction has those services. A youth charged with the delinquency petition has access to DJJ funding for services. And so that is why, in some instances, a prosecutor will file a delinquency petition against a youth under age 11. It's not to hurt them, it's to get them services.
Got it. Thank you, sir. I think Senator McDougall has a question for you.
Mr. Chairman, I think that a lot of us support the concept or the thought process of where Senator Locke is coming from, that you do not want juveniles to be delinquent or have a criminal record. But I do have some real concerns procedurally in some types of cases. So my understanding that a number of jurisdictions require a parent or guardian to bring a CHINS petition, and it is discouraged for a law enforcement officer to bring a petition that is not for a crime that would be delinquent. So logistically, what would happen with a 10-year-old child that pulled a knife at school? How would that person get to the CHINS process for the court to do something?
If a law enforcement officer or a Commonwealth's attorney did not bring a CHINS petition, I believe that then wouldn't happen.
Mr. Chairman,
Senator
I might be incorrect about that.
I think we historically have discouraged law enforcement officers from bringing petitions for things that are not criminal. So how would they even be in the loop to bring something for now the 10-year-old that produces the knife at school?
Well, I think one possibility is that they could come before intake and on a delinquent offense, and the.
Well, Mr. Chairman,
Senator McDougall.
In that the problem, there's no delinquent offense now. You can't have a delinquency under the age of 11. So logistically, if the parent doesn't go for the CHINS, there's no guardian appointed because there's no guardian in place. Law enforcement is not bringing a petition for delinquency. Who brings it? Who even has standing to bring it?
I believe you're correct.
DJJ, so you're saying nobody has jurisdiction to bring any kind of help, a petition for services under age 11 if we pass this? Is that what you're saying?
Under current law, and I believe that is the case, yes.
So, Mr. Chairman,
Senator McDougall.
I think the parent has the ability to bring it.
Yeah.
I think a guardian has the ability to bring it. But
the government.
Mr. Chairman, can we ask Mr. Benjamin who can bring a petition?
Senator Perry. Senator Perry, I think, has a question for Mr. Benjamin.
She
Mr.
caught
Benjamin's
me
declining.
obviously not paying attention, Mr. Chairman. So.
Mr. Benjamin, the question
Senator Perry.
is, Mr. Chairman, the question is for Mr. Benjamin, if he could answer it, who can bring a CHINS petition? I know that CHINS truancy can be brought by a truancy officer. I know that parents can petition for CHINS. I think other people can also petition for CHINS, child in need of services or supervision.
Mr. Chairman, with apologies, Senator Perry knows far more than I do. If I brought a CHINS petition or answered that question, it'd be malpractice. Sorry.
So my question, Taylor might be able to answer, but I believe CHINS petitions, somebody has to go to an intake officer and petition the intake officer, and the intake officer issues the CHINS, right?
Mr. Chair, that is my understanding. I did just want to point out, because I don't know if it will change the conversation, but we still define delinquent act as an act designated as a crime under the laws of the Commonwealth, which is otherwise lawful but designated a crime only if committed by I've skipped part of the definition. But we did not change the definition of delinquent act. We just changed it of delinquent child to say a child 11 years of age or older. So I don't know if some of this is tied to a child that's committed a delinquent act in order to get to the process of the intake officer, and then if they would fall under the child in need of services. But I did just want to point out that delinquent act definition stays as is. But
and as I mentioned, one of the problems with CHINS is
Sir,
is that
you had an answer to what she said? Go ahead. Sorry, you have to come through me, that's all.
Yes, Mr. Chairman. I'm not sure what the question was.
I've got a question.
Senator Peake, you had a question.
I'm completely confused, Mr. Chairman, so whoever can answer this. A delinquent act is anybody who commits a crime. So am I correct, or am I completely misreading this? If a 10-year-old commits a rape, robbery, or murder, does this statute mean that they're not charged with a crime? Is that They cannot be charged? Is that what this bill means?
Question for Taylor, Mr. Benjamin, I think.
That's what it looks like.
Mr. Chair, the bill as written says that the juvenile is not going to be adjudicated delinquent. There may be an avenue for them to be proceeded upon as a child in need of services, depending on if they meet that definition, but they're not allowed to be proceeded upon as a delinquent juvenile. There is the section that says that the court can still, at the very end of the bill, it does add that new section on lines 361 to 364 that says the court can still make dispositions that they're allowed to make for delinquent juveniles, but they're not going to be adjudicated delinquent or proceeded upon as delinquent.
Mr. Chair?
Yeah, Taylor, I think his question is, what does that mean?
Yeah, so are they still punished, Mr. Chair?
Senator Peake.
If they commit a rape, robbery, or murder at the age of 10, so they're not declared delinquent, are they still prosecuted for the crime?
Mr. Chair, that's correct. They would not be, yeah.
I'm sorry, what was the answer?
The answer is yes. You're right.
They're still, I'm correct.
Mr. Chairman, I
I
think
am
Senator
correct.
Peake is correct.
That is so rare.
Senator McDougal.
Mr. Chairman, I guess my question is even before that. How do you even get in front of the court? How do we get there? So we have everybody would say if a child cuts somebody at school or has a gun at school and they're 9 or 10 years old, we want something to happen to protect the rest of the children at school. What is the mechanism that gives anybody the ability to do that? Right now, it would be a law enforcement officer would have a petition issued and would take them into custody. If I'm reading this right, that's no longer going to be possible.
Mr. Chairman.
Senator Perry, you have an answer?
I'm just pulling up Virginia's judicial system website. I haven't been able to access the code yet to figure out the exact answer to your question, but I think previously we were having the conversation about going to juvenile court services, JCSU, right? That's where petitions originate for juveniles. When I'm looking at the court services website right now, it says the court procedure for a child in need of services. It says a person who wants the court to consider a child as a child in need of services must file a petition with the intake officer of the court service unit. So I think that would be the proper procedure, is that a law enforcement officer, a parent, another responsible adult would go to JCSU and request a petition for a child in need of services.
Okay, but is OES here? Ms. Carrison? Have you all looked at this? The juvenile court judges, have they looked at it? Have they given us, you want to come on up? Because I usually hear feedback from you all about things like this.
Mr. Chair,
Huh?
if I could just add something to your question.
Okay, and Senator Deeds, you want to add something to my question?
Maybe you could help clarify. Right now, under the common law, there's a presumption that if you're under age 7, you're not guilty. You can't be charged with a crime. Do we have data on how many kids 8 to 11 have been charged with crime, felonies, or crime at all, and how many have been convicted?
Mr. Chairman, members of the committee, Sandy Carrison, Office of the Executive Secretary, Supreme Court of Virginia, Senator Deeds. We could probably pull some data for you if you would like to have information. I certainly do not have those data here today. Senator Locke says she has data. In terms of court process, I think that what's on the website is accurate, that the child in need of services or supervision petition initiates with the intake process, and the statute is 16.1-260. Senator Perry was looking for that. That's the statute, and that statute permits the intake officer to divert the child in need of services or supervision upon request for petition, in order to get services in the community before there's any court intervention. As far as this bill is concerned, I did not register any position on the bill from the judges who reviewed. any court position. I don't have a formal court position, but I would be glad to be of service here to the
Okay,
committee
but it was
as I
reviewed.
can.
It was
Sir?
reviewed. It was reviewed.
Yes.
Okay, thanks. Senator Locke, you got some data?
Yes, and the Virginia Association of Commonwealth's Attorneys would also like to come up and speak if you would have them. By age, 130 young people in 2023 under the age of 11. By sex, 85, 27 women, 27 female, 58 male. By race, 42 African American, 37 white, 7 others, for a total of 85.
That's in 1 year.
That was in 2023.
Senator Deeds.
How many were convicted, or are those just the ones that were charged?
These were charged. Let's see. Intake cases, 80%. 80% were dismissed.
Thank you, Senator. Okay. I think Senator Locke was inviting Mr. Green with Vodka to come on up and give a point of view. Is that right? I don't know where we are on the timer. I guess we had about 30 seconds left in opposition. Where are you?
Excuse me, Mr. Chairman, Virginia Association.
You're offering technical help to somebody's question.
Technical help if anybody has questions, but we are not taking a position on the bill. My understanding is that you would proceed on the Delinquent Act. The police would proceed on it the same way they normally would. When it gets to court, the judge will act differently. The judge will not find them delinquent, but rather will find them as a child in need of supervision, and will then, there are minimal differences between what a court can do with regards to a CHINS finding versus a delinquency finding. There are minimal, but there are some, but they are very minimal.
Okay, Senator Deeds, I think, has a question.
You heard Mr. Toohey talk about changes in the ability to access funding to do services. What's been your experience in that area?
Mr. Chairman, to answer that question, we normally go through our FAPT team when we have a child in need of services. There is funding available. These kids do have the ability to have access to resources. Whether or not DJJ is aware of resources that they would not be available to, that I am not familiar with. But we proceed on CHINS petitions, not on kids this young, but on kids that are not going to school or have other issues, and rather than go the delinquent route, we go the CHINS route. And again, there are a number of resources that are still made available to our kids.
Okay, thank you. All right, we've
Mr.
talked
Chairman.
a lot on this. Senator, who's that, Perry? Perry.
And I just apologize. There was some confusion on the dais, and I understand how it came about. When I was having the conversation with the gentleman from DJJ, or from Department of Juvenile Justice,
Yeah.
who came to visit me, I think there was some initial confusion about whether the services were the same if you were charged with the Delinquent Act or whether you were charged with the CHINS action, whether you could get the same services. And I was initially told that they were different. But he did come back later and clarify to me that the services are the same. It's just a funding issue, as Mr. Green was pointing out. So I just wanted to clarify for the members of the dais.
Okay, thank you, Senator. So we've talked this a lot. Senator, you want to provide us with any lucidity before we take action here?
Sure. Mr. Chairman, we can come up with the most heinous crimes ever, and we can talk all day about the most heinous crimes ever committed by a child under the age of 11. We can come up with them all day. And the most absurd crimes all day. And I pre-filed this bill. So it's been out there since November. No one from DJJ has spoken to me about this bill. No one. So I am disappointed for someone to come up here today and speak in opposition to a piece of legislation that they did not have the courtesy to come and talk to me about it prior to today.
Hey, thank you, Senator.
Mr. Chairman,
Mr. Benjamin.
I should also add that another code section that does not appear to be affected by this bill sets out a number of situations when a child may be taken into immediate custody. And that would include, for example, when there's probable cause to believe that the child has committed an offense, which, if committed by an adult, would be a felony, if that assuages anybody's concerns.
Okay. All right, so we've talked this thing to death. It went a lot longer than I thought it was going to be. Does anybody have a motion? It's been moved and seconded. We report the bill. Clerk will open the roll. Wow, that's an interesting vote.
Ayes 8, noes 4, abstentions 3.
Thank you, Mr. Chairman.
Thank you, Senator. And if that little girl knows anything about class actions, I could use her in a minute. Senator Lucas, when the President pro tem walks in, she doesn't have to be on my list. So why don't you tell us about this bill we passed last year?
Thank you, Mr. Chairman and members of the committee. I served on this committee for over 20 years, and about the only thing I miss is Mr. Benjamin.
Yeah, what about us? Yeah.
He didn't even hear what I said. Over 20 years old serving on this committee, the only thing I miss is you. I'm sorry. Oh, that's right, all of you. Everybody up here isn't new. I miss you, Richard. Mr. Chairman, members of the committee, last session, this committee worked diligently to have this bill passed, and ultimately the Senate Finance, I got finance on the brain. The Senate passed this bill 31-9 in 2023. I brought it back with the fixes that were made and hoping this will be the easy vote for the committee. Brief history. In 2021, Virginia became the first state in the South to end the prohibition of simple possession of adult consumption in private areas, as well as home cultivation with private labeling and storage. Unfortunately, parents 21 and up may still have their custody and or visitation impacted by legal and responsible use of authorized substances such as marijuana. Some Virginia courts are mandating clean drug screenings, and we know all of that. But Mr. Chairman and members of the committee, this bill is a housekeeping component of decriminalization to free up our courts and families from outdated policies, not just for marijuana, but to cover all unauthorized drugs. To be clear, this bill still leaves room to find negligence for misuse of unauthorized substances that would not be in the best interest of the child, or if found to be abusive or neglectful. And as I said, this is a house cleaning bill. It came to you last time, and if you stay here long enough, you'll see a lot of these bills a dozen times. So, Mr. Chairman, a lot of you have.
So, Senator, this doesn't say that if somebody's abusing marijuana, a court can't consider it. It only just says that if the judge just can't say if marijuana is present in the house, you can't be a parent anymore, right?
That's correct. That is correct.
Okay. Any questions for Senator Lucas?
Mr. Chairman.
Senator Jordan, you keep using the button.
Sorry, sir. I'll be disrespectful if that's your request. I don't think I have a question for Senator Lucas, but I believe I have a question for counsel. So if a parent in a custody situation has other court orders where they're restricted from, alcohol or in substance abuse training, would that have any bearing on this instance?
Mr. Chairman, Senator Jordan,
what substances will this apply to?
Gosh, everything under, Mr. Chairman, the sections in the code. So as I understand it, it would be anything for which you have a prescription, a lawful prescription, and any substances covered by Title 4.1.
Follow-up question.
Go ahead, Senator Jordan.
Thank you, Mr. Chair. I think my concern, and I don't know if this is something that Senator would be amenable to, but would it be appropriate for us to lay out Schedule I drugs or something of a more heinous nature? I think I know what your intent is to, as we legalize marijuana, if that should happen. But there are some other drugs I think that are more lethal, like fentanyl and other things, so that I think would be important to include.
Well,
Mr. Chairman, I think that concern is dealt with on line 25, where you say authorized. And so the substance would have to be authorized under Virginia law.
Right. Senator Stewart.
Mr. Chairman,
I read this quickly, and again, I'm just a dumb country lawyer here. But if I read this bill correctly, and help me if I'm not, the fact that you smoke marijuana is not a basis from which to restrict custody.
That's correct.
You would have to be abusing it
That's correct.
to the extent that it creates a risk for the child for it to be used against you. Is that a proper reading of the bill?
Yeah.
Okay, thank you.
Mr. Chairman, that illustrates the single concern I have about the wording used because we use the word alone. And I'm concerned that once the bill leaves the General Assembly, courts will focus on the word alone. And my concern is that they will say, well, what this means is that if a person occasionally uses marijuana, that fact, just that fact, cannot be a basis for making these determinations. But if you add any other fact, such as a child being present in the home, then that could be used as a basis. And so if that's a concern for the patron, I wondered whether the word alone should be stricken from the new language. Because you still have the clause that says, unless there are other facts that create a substantial risk. You still have that language. I'm just worried about that word alone, and the court's wondering what that means.
Senator Stewart.
And not debating Mr. Benjamin, but haven't we passed law that says you can't smoke a cigarette around a child? Can in a car. I don't think you can in a house either, can you? Indoors. There have been a number of those bills. I'm just curious, adding to what you just said.
I'm not sure. Okay. Is anybody else worried about the word alone being a word that creates a bad ambiguity? No, it doesn't look like anybody else says. Okay, why don't we set it at 3 and 3, and come on up. Those in support, come on up.
If there's anyone online that would like to speak in favor, please raise your hand.
Hi, my name is Chelsea Hicks Wise. I'm with Marijuana Justice. We've been working with the patron for a couple years now to continue to pass this bill, and we did include the word alone in order to try and make sure that that one solo piece was not the entire reason for that. So we'd be open for more discussion about that, but definitely want to make sure that that doesn't open up more cases for folks to have unintentional consequences with custody and visitation. So thank you.
Next.
Mr. Chair, members of the committee, J.M. Padini on behalf of the National Organization for the Reform of Marijuana Laws. We thank the patron for continuing her work on this important issue. Since the passage of the initial iteration of the medical cannabis program way back in 2015, we have a laundry list of calls and emails, notably from counsel representing people in divorce cases where custody is in dispute, and this is a much-needed fix. Thank you.
Thank you.
Mr. Chair, members of the committee, Allison Gilbreth with Voices for Virginia's Children. We thank the patron, support the bill. We hear from families all the time the trauma that children experience when they go to have a visitation with their parent and aren't able to because of this. And this bill would really alleviate a lot of unnecessary trauma for children in Virginia. Thank you.
Mr. Chair and members of the committee, Valerie LaRue from Virginia Poverty Law Center, and for most of the reasons already stated, we support this bill because we do see this being used against parents in both custody battles and also for parents who are working diligently to get their children out of foster care. This is sometimes used against them. We do think that the point of counsel about the word alone is well taken, but maybe that's something that could be worked out in conference. Thank you.
Thank you. Maisie Osteen on behalf of Legal Aid Justice Center and our Youth Justice Group, and we support this bill. Thank you.
Monica Hutchinson from Rise for Youth, and we support this bill. Thank you.
Mr. Chairman, members of the committee, Tammy Miller Jennings with Virginia Chapter of the National Organization for Women. We firmly support this bill. Thank you.
Okay. Anybody online for the last 45 seconds?
Mr. Chair, there's no one that wants to speak.
Okay, we can move to the opposition. Is there anybody opposed to the bill?
If there's anyone online that would like to speak in opposition, please raise your hand.
Okay, I don't see anybody present in person opposed. Is there anybody online opposed? Nobody?
Move to report.
Okay, Senator Deeds moves, Senator Boyce goes seconds. Do we report the bill? Any further discussion? Clerk will open the roll.
Ayes 15, no zero.
Bill reports 15-0. Is that your only trip to us this session, Senator?
I do believe so, Mr. Chairman and members of the committee, and if I might leave you with one word of advice, never debate with Mr. Benjamin.
Thank you, Senator. Next up, I've got D. Steph, McGuire, Favola, then Pillion. That's my order. Then Williams, Graves, and Durant, just so you know where you are in the queue.
Mr. Chairman, members of the committee, I've got a very difficult, complicated, complex bill here. It's about marriage. And this bill just says...
For or against?
It just says who's allowed to perform the act of marriage in the Commonwealth. We're adding, first of all, we have a line amendment we'd like to provide. Sorry.
Yes, Mr. Chair. Everyone should have a copy already distributed. The line amendments are on line 24, after Governor of Virginia, strike or, and then also on line 24, after General of Virginia, insert or Romanet 5, Clerk of a Circuit Court of the Commonwealth.
Okay, Senator Deeds moves. Senator Boyce goes seconds. The line amendment. All those in favor say aye. Aye. Anybody opposed? Nobody's opposed. Okay.
So, Mr. Chairman, what this does, it adds the clerk of courts of the Commonwealth, along with former members of the General Assembly, former governors, former lieutenant governors, or former attorney generals, to be able to marry people. I know it seems very complicated, but that's it. I thought most of them could do it anyway.
Have we already passed, Mr. Chair?
Senator Deeds.
Have we already passed this bill?
Not that I'm aware of, Mr. Chairman. Senator Deeds.
Yeah, former is new. Former is new.
Yes,
Senator
Mr.
Deeds.
Chair, the current members were added in 2021 special session by Senator Cosgrove's SB 1142.
And, Mr. Chairman, this just
Senator-
says former, so former governors can marry people, former members of the General Assembly.
Okay. Everybody understand the bill? Any questions? Set the timer at 2 and 2. Anybody in favor? Anybody online?
If there's anyone online that
Anybody
would like to
opposed?
speak in favor, please raise your hand.
Okay. Anybody opposed?
If anyone online is opposed to the bill, please raise your hand.
Mr. Chair.
Nobody.
Mr. Chair.
Oh, Senator Jordan.
I have a question for the patron.
Go for it.
Senator Steph, do you have a list of governors that you entrust with your rights of marriage? And if so, could you say who they would be?
Mr. Chairman, Senator Jordan, I do have a couple of former governors that live in my district that I would trust in performing the rites of marriage. Although I believe marriage is between two individuals and God, or their God, and that's kind of what I believe. I believe that the individual performing the marriage, being a former governor, member of the General Assembly, Circuit Court of the Commonwealth, anyone else, that they should certainly have the ability to do that act.
Thank you, Senator. Mr. Chair.
Senator Jordan.
Move to report.
Okay. Is there a second? Second. Okay, it's been moved and seconded that we report the bill. Any further discussion? The clerk will open the roll.
Mr. Chairman, members of the committee, thank you very much for your time.
Ayes 15, no zero.
Okay, next up we have bill reports. Next up we have McGuire, unlawful picketing or parading a Supreme Court justice.
Mr. Chairman, would you mind if we did 6:30 first, or does it matter?
Oh, sure. And you had a witness, so I didn't want to get out of here on that one, but we can go to 6:30 first if you like. So, Senator, there's a little issue with this one. We got a letter from the Senate Finance Committee about it, saying they wanted to take a look at this one. And we just got the letter today, I think. And the deadline for finance bills was Tuesday under the I think it was a joint resolution about that, right? Isn't that the joint resolution?
That might not be this bill.
Yeah, it was 6:30.
We were told there was no fiscal impact because it doesn't fall under the workers' comp. It's just for.
Yeah, Senator, I got it. I'm just telling you, if it's a finance bill, I think it might have expired pursuant to the procedure resolution, I think. Yeah, can you find out? Why don't we do your other one first so we can figure out what's going on? But
Sure.
whether that finance deadline is informal or whether it's actually in the resolution. Okay?
Okay, so we're going to do SB 223, is that right, Chairman?
Yes, unlawful picketing.
Sure. All right, Mr. Chairman, members of the committee, Senate Bill 223 introduces a penalty of a Class 1 misdemeanor to any person with intention of interfering or influencing by picketing or parading near a court's official's residence. This is for the safety and protection of those working within the state legal system, judges, jurors, witnesses, court officers, and court employees. Within freedom also comes the right to protection, especially when people are in the safety and privacy of their own homes. There have been instances of picketers in neighborhoods or on sidewalks right outside Supreme Court justices' residences. This crosses the threshold of lawfully expressing and advocating ideas, turning into a possible dangerous territory or harassment. Attempting to scare court officials or influence a case in this way is unethical. It defeats the purpose and process for a fair and just trial. Judicial independence and neutrality is needed in democracy and important in consideration of all opinions. Placing a penalty of a Class 1 misdemeanor is a firm reminder that it is wrong to obstruct or influence justice, as it attributed to intimidating behavior can cause harm to others. Media sources say that threats against judges are up 400%. And hope you guys will pass the bill.
Mr. Chair.
Hey, Senator Deeds.
I'm looking at line 19, lines 18 and 19, in or near a residence occupied or used. How do you define near? How close does it have to be near?
You know, Mr. Chairman, I have Richard Cullen here to speak on this. He may be able to speak better to that to me. If that would be okay.
Mr. Cullen, why don't we just set the timer at 3 and 3? Are you? Well, he's answering a question, I guess. We won't start the timer yet. But.
I want to know what's near mean. How close is that for this to apply?
Mr. Chairman, Senator Deeds, Richard Cohen, Office of the Governor. Near would be a question of fact for the trier of fact. It might differ if it's in the country versus if it's in the city. I think the key would be if the picketers or protesters were close enough to affect the use and enjoyment of the home.
Well,
Senator Deeds,
Mr. Chair, if it means different things in different places, is it too vague?
I don't think so. I think, Senator, that if it happened to be a jury trial, there would be an instruction that would define it for the jury. If it were just by the trier of fact, after he hears the evidence, he would be able to determine whether or not it was near.
But Mr. Chair, the jury instructions, it's been my experience, they're drafted basically instructed by the code or by the case law. And there's not any case law in this section right now that I know of. And so how would you define near in a way that for a jury instruction? What do you think, how would that read?
Close enough to affect the people in the house so that they could hear the demonstration outside, and that it would be close enough that it would affect their ability for the use and enjoyment of their home.
Okay.
Senator Deeds, another question? Well, Mr. Cole, I know, for example, I live near a Supreme Court justice, and I walk my dog near his house from time to time, not in front of it, but near it.
Yes.
And I could be 2 houses away, and I'm sure he could hear a loud muffler on the road or a loud protest that's like 2-3 streets away. I mean, so if it's just a matter of hearing it in the house, that's pretty far away. I don't know how anybody's supposed to know whether somebody can hear something in the house or not. Right?
So if I could, Mr. Chairman, revert back to the summer of 2022 after the Dobbs decision came down. And I know one of your neighbors, I think, may have had his hand in that opinion.
Yeah.
And you probably better than anybody else will know whether what I'm saying is true or not. But night after night, week after week, there were demonstrations, there were loud horns, there was music, there was chanting, and it was so intense that this particular justice had to leave the home and go live somewhere else. More importantly, in my opinion, was another of the Supreme Court justices who lived in Fairfax County on a cul-de-sac, and the same thing, night after night, week after week. And not only was the peaceful use of the occupancy of her house hindered, but neighbors who were in the cul-de-sac complained to the husband about what was going on and what could be done quickly, because I know you're time limited.
Okay. Mr. Chair, I would ask the patron if he would agree to a friendly amendment and to strike on line 18 or near and put pickets or parades within 100 feet of a residence. Strike in or near and put within 100 feet, which would be 30 plus yards, which would cover being across the street or 30 yards on either side of the residence. So would you consider that a friendly
Mr.
amendment?
Chairman, I'd like to speak to that. You know, we have some very knowledgeable members of this committee. In fact, we have a good country lawyer. We have a good big city lawyer. We have another lawyer who likes to measure 3 times like a carpenter and cut once. Yeah. But I think that would be great. And as lawyer, I think that would solve the problem, because I think we would agree this is not a partisan issue. We wouldn't want it to happen for any of our justices where people can use intimidation to influence a decision in the court. So I think that would be a friendly amendment if it would make sense to the rest of the committee.
Okay, is there a second to that motion?
We have some discussion about that first.
Before we amend it, go ahead. Senator Stewart, I think, had discussion on the motion.
And perhaps the
the
paper
idea.
wants that amendment, but I'm guessing that's about from here to that wall back there is 100 feet. And maybe I'm mistaken. I really would like to mention another point to your point in Senator Deeds, and I don't think you can read the word near in a vacuum. I think you have to read the statute in its entirety, and this is a specific intent crime. And I believe Mr. Cullen is right that this would be an issue for the trier of fact to determine if in fact they had the intent to do what they were doing and it was close enough to accomplish that intent. I don't see any vagueness in that. And I'm concerned that if you put a specific distance in, the act could still be accomplished and fall outside of the statute. So, and perhaps I'm wrong, but you know, I look at this and it's just like we're discussing election workers all over again. And this committee was happy to extend this to election workers, and I think we need to extend it to those that administer our judicial systems as well, because they're the hallmark of our society. And it's incredibly important that they be able to do their work without being intimidated or harassed.
Mr. Chairman?
Mr. Chairman. Hold on a sec. Are you responding to what Senator Stewart said, Senator?
Well, I was just told that it's in the federal code that the near term that we use is how it's worded in the federal code, which is probably how we came up with it.
Mr. Chair. Okay, hold on. Wait a second.
Mr. Chair.
Hold on, wait a minute. You withdraw your motion? Yeah. Okay, Senator Jordan was next, and Senator Bagby.
Mr. Chair, I'd like to ask a question for Mr. Cullen. Can you, maybe you can answer this as an attorney, but federal code, was this designed, or would you say this mirrors near or very close to federal code?
It does. It mirrors it. During that summer, governors of Maryland and Virginia wrote to the Attorney General asking him to enforce the federal code, but they wouldn't. And then immediately thereafter, the marshal for the Supreme Court, Gail Curley, wrote to both those governors and asked them to enforce the state law. Fairfax County, Mr. Chairman, refused to do it under the guise that statute, I think it's 18.2-419, was unconstitutional. And so I think the genesis of this bill was to answer any of those constitutional issues.
We need to get some time constraints on this. We're going to be here forever. And
Thank you.
We're not going to be here forever, Mr. Chair.
Well, Senator Bagby, you're about to make a motion?
Yes, Mr. Chair.
Cool. Can we take opposition first, so we can see if there is opposition?
Mr. Chair, we have a long docket. It's clear that this bill is not ready for us. I got to make a motion to PBI.
Chair, speak for the moment.
Okay, it's been moved and seconded to PBI the bill. Senator Obenshain.
Mr. Chair, members of the committee, this bill is, with due respect, it is ready for prime time. It's the same law that's passed Congress. It is a demonstrated problem. The existing law is unenforceable because of the viewpoint discrimination that is contained therein, and because it doesn't have an exception for organized labor and related issues. This clearly complies with constitutional standards. We just passed legislation providing exactly the same protection to election workers, and we're not going to apply the same protection to the judges that we elect all over the Commonwealth of Virginia, jurors, court personnel, federal judges who are appointed by President of the United States. This is absolutely critical to maintaining order and protecting the administration of civil and criminal justice in America. So I would hope that we do not pass this by indefinitely, and I would hope that we would report it, and as a consequence, I make a substitute motion to report this bill.
Mr. Chairman, first, a technical correction.
Yeah, go ahead, Mr. Benjamin.
The bill that was passed the other day or reported out dealing with election officials, the conduct described in that bill was included threats to kill or do bodily injury, or by bribery, intimidation, threats, or coercion.
Right. It didn't have to do with simple picketing.
If I can respond to Mr. Benjamin.
Go ahead, Senator.
I respectfully disagree with Mr. Benjamin today, as I did then, with respect to the construction of that bill.
Thank you, Senator. And I would just note, the chair's concerned is, if you read this carefully, it says any person with the intent of influencing in the discharge of his duties, these people, pickets. It seems to me the whole purpose of a picket is to try to influence somebody. So, it seems I'm not really clear under the First Amendment how this really works. So,
You need to go back on the First Amendment.
so I was about to call the motion to vote. Senator Boyska, you have something? Okay. We've debated this plenty. So there's a motion before us to report the bill. It's a primary motion. All those in favor, vote. You can open the roll.
Ayes 6, noes 9.
Okay, we go back to the motion to PBI.
Ayes 9, noes 6.
Okay. Thank you, Senator. I think go back to your other bill. We got word from the Finance Committee that it's not a joint procedure resolution issue. It's a Senate Finance Committee request, so I'm not sure how they're going to receive your bill if we report it. But so go ahead and present your bill 2:30.
Sure. So I spent 24 hours visiting every dispatcher unit in my district, 10 counties. I visited large cities like Charlottesville, which had one of the largest dispatcher units, Lynchburg, and Danville. And I spoke with dispatchers, and they are, for all intents and purposes, classified as secretaries in Virginia. But what I found out in talking with these dispatchers is they have quite a bit of medical training, and they're usually first on the scene when someone is attacked or there's been crime against them. For example, if someone, some of the dispatchers said they had phone calls where someone called up and they said, "I've been shot." And the dispatcher talks them through how to put a tourniquet on or how to do CPR and things like that. And they deal with things like PTSD. and they're often first on the scene. So I talked with many sheriffs. They all agreed this was a good bill. It's a bipartisan bill. And it introduces add 911. Oh, wait a minute, I have to move an amendment first. Can we move the amendment, Mr. Chairman? It should be on
Is that
LIS.
previously distributed?
Yes, Mr. Chair, it should be in your packets, and it just adds dispatchers employed by the Department of State Police to make sure that state police dispatchers are also eligible.
Yes, the state police asked me to do that.
Okay. Senator McDougal moves, Senator Peake seconds. The line amendment, all those in favor say aye. Aye. Anybody opposed? Nobody's opposed. Okay, Senator, so
Sure.
you got that in front of us.
Okay, so the bill introduces add 911 dispatchers to the definition of public safety officer to be eligible for possible selection by the governor for the Commonwealth Public Safety Medal of Valor Award. 911 dispatchers work as first responders in handling emergency situations as they happen in real time. They work alongside the police, fire department, and emergency medical services and are a critical part of the communication and transitioning process. The 911 dispatchers are the first point of contact for the victims and or witnesses on the scene of an emergency. Dispatchers have a critical job in which life-saving measures could not take place efficiently and as effectively without their role. They are required to think and act quickly in order to provide as much off-site help as possible. We can further show our appreciation and reverence for emergency 911 dispatchers by viewing them directly as public safety officers and adding their eligibility for selection of the Commonwealth Public Safety Medal of Valor Award. And again, this does not, because they are inside a building, it does not have the same workers' comp.
Does anybody oppose the bill? It didn't appear to be anybody opposed to the bill, Senator. It has to be re-referred to finance. So Senator Peake moves, and does anybody second it? Second. Senator McDougal seconds to report re-refer the bill to finance. Any further discussion? Although, clerk will open the roll. Okay, Senator, oops.
Ayes 15, no zero.
Okay, Senator, I think you got one more about sanctuary cities.
Yes, sir.
Senate Bill 720. I think we've heard similar bills to this before in the past, although it's been a while.
Sure.
Why don't you explain 720 to us real quick?
All right, Mr. Chairman, members of the committee, Senate Bill 720 requires localities to cooperate with federal law enforcement and enforcement of immigration law. Across the country, cities have set policies of not doing so, creating what they call sanctuary cities and leading to massive influxes of illegal aliens, homelessness, drugs, and crime. The burden to fix these problems falls on lawful taxpaying Virginians, and that should not be on their shoulders. Our law enforcement needs support in doing their jobs and telling them to enforce some laws and not enforce other laws creates confusion as well as conflict between federal, state, and local governments. The issue of immigration is a large one that is the duty of the federal government, and although they have failed lately, the state of Virginia and our localities should not make the problem worse by not helping to enforce those laws. This is a common sense bill that prioritizes the safety of all Virginians, no matter what political party you are in, religion you worship, or your race. It is my belief that Virginians are proud to welcome all people who come into the country legally, and I ask that all members of the committee pass this bill to protect the people that we are here to serve.
Thank you, Senator. Senator Black here to support your bill? Just kidding.
What was that? I didn't hear what you said.
Okay. We've seen this bill, heard it before. I think everybody understands it. Is there a motion? Okay, Senator Boyska moves, Senator Bagby seconds. We PBI the bill. Clerk will open the roll.
Ayes 9, no 6.
Thank you, Senator.
Thank you, Mr. Chairman.
Next up is Favola still back there somewhere.
I am.
Right behind the podium. I can barely see you. Okay. Senator Favola, we have 15 and 16. Which would you like to do first?
I will do 15 first, and these are very straightforward bills.
Okay, 15 was the bill that I carried last year, minus.
But mine is just much simpler. I like to keep things simple. You like to keep things complex.
That's right.
Let's go to the. There are two line amendments, and I would say on line 18 after.
Have the line amendments been distributed?
Have they
Yes,
been
Mr. Chair. They're up with everybody in the packets.
Okay.
Okay, Central.
Then I would ask that you adopt the line amendment.
Okay, I see. Okay, Senator Boyska moves, Senator Floyd seconds. Adopt the the line amendments. All those in favor of the line amendments, say aye. Aye. Anybody opposed? No. Okay, the line amendments are done. Senator Favola, why don't you explain to us
Okay.
this bill that we passed last year does?
Mr. Chairman and members of the committee, what this does is it would protect an individual who came to Virginia to get an abortion from a state that had banned abortion care from extradition, and it would also protect a provider in Virginia who had provided that care, or healthcare professionals who had assisted in that service from extradition. And that is the bill.
Thank you, Senator. Are there any questions for Senator Favola? Is there?
There may be a speaker in favor.
Why don't we go 2 and 2, because we've heard this before.
I did not
last
ask
year.
for speakers to come. But
Okay, we're going to limit it to 2 and 2 per side. And
If there's anyone
2.
online that would like to speak in favor, raise your hand.
No.
Denise Harrington, the League of Women Voters of Virginia. The League of Women Voters of Virginia supports this bill. We live in the United States of America, and it is horrifying that a citizen is able to have government intervention in her body. No healthcare professional should have to face retribution for performing a procedure on a woman or a woman for having a procedure done just because of the whim of the government. This is a very real threat. Texas law lets private citizens sue out-of-state abortion providers, and Missouri is considering even a similar law. Please do not bring the stench of criminalization of women and healthcare professionals to Virginia. 77% of Virginians support this procedure being safe and legal. Thank you.
Sorry, you didn't identify yourself when you spoke.
I'm sorry. Denise Harrington, Director of Advocacy with the League of Women Voters of Virginia.
Thank you. Okay, next up, we got 1 minute left. We got a lot of people.
My name is Dr. Wendy Klein. I'm a physician with my expertise is women's health, and I am here to urge you to stand up and help draw the line against those who would criminalize and stigmatize providers and patients in their efforts to access legal abortion, contraception, and pregnancy-related care. Those who seek and those who provide abortion services must contend with fears of legal repercussions and an ever-shifting landscape of information and access simply because the intense politicization of abortion obscures its status as a health care issue. I ask that you safeguard and protect providers and patients to allow compassionate, thoughtful care without undue interference in necessary, complex, highly nuanced, and deeply private healthcare decisions. I urge you to support this bill.
Thank you, Doctor. Everybody else, time's expired, but you just state who you are, who you're with, and whether you support the bill.
Tammy Miller Jennings with the Virginia Chapter of National Organization for Women, and we strongly support the bill. Thank you.
Monica Hutchinson, President for Henrico County NAACP, and we strongly support this bill. Thank you.
Katie Page with the Virginia affiliate of the American College of Nurse Midwives, and we support this bill.
Hurry up.
Tarina Keene with Repro Rising Virginia. We strongly support this bill.
Brianna Acilio, Virginia. We support.
Hi, Latoila Matthias, Progress Virginia. We strongly support. We thank the patron for bringing it.
Good afternoon. Gabriela Watson with the National Latina Institute for Reproductive Justice. We support this bill.
Galina Vachena, Birth and Color. We support. Hi, Jamie Lockhart, Planned Parenthood Advocates of Virginia. We support as well.
Nicole Lauder with American College of Obstetricians and Gynecologists, and we support the bill.
Taye Mallory, you may unmute and speak.
Just state who you are and where you
Taye
support
Mallory,
the bill.
Virginia NAACP, and we support.
Great, thank you. Okay, can we go to opposition now? Anybody in opposition, reset the timer, please.
If there's anyone online that would like to speak in opposition, please raise your hand.
Mr. Chair, members of the committee, Jeff Caruso at the Virginia Catholic Conference. On the one hand, we're against prosecuting or criminalizing women who have had abortions. But on the other hand, when you place a protective shield around abortion providers that break other states' laws, what you're really saying to people in other states is, if you want to obtain an abortion, provide abortion, or assist with abortion, come to Virginia. This bill treats abortion differently than everything else. It gives it unique, elevated, and exclusive status in Virginia law. Rather than advocating rather than advancing this bill, we urge you to instead seek laws that protect mothers and their children from the tragedy of abortion and that help families. Thank you.
Thank you, Mr. Caruso. Next up.
Mr. Chairman, members of the committee, I'm Olivia Turner, president of the Virginia Society for Human Life, and every year on these occasions when this bill comes up or things like it, I speak for the women of Virginia, women who are having abortions and women from other states who may find themselves injured, harmed, maimed, or in some way unable to follow through when there has been some crime committed against them. If Virginia passes laws that protects abortionists, it does not protect women like myself who have had abortions, women who absolutely have to have the ability to identify who has committed a crime against them, and even if that individual is from another state, our state cannot deny them access to the proper legal channels to achieve whatever they need to for justice sake. This is about justice for women. This is not a situation where we need to continue to practice any situation that protects abortionists at the expense of our lives and our safety. Making Virginia a safe haven state does not help women. That's why VSHL will always oppose bills like this.
Get close to the podium. Losing time.
Hello, I'm Susan Musket, president of Pro Family Women, and we oppose this bill. Not only does it undermine efforts to protect unborn children by life-affirming states, but it encourages a scenario whereby women are left to return to their home states and navigate any abortion complications on their own. SB 15 will turn Virginia into a destination state that attracts women seeking abortions and abortionists seeking to profit. This is not what our great Commonwealth should be known for.
Mr. Chairman, Josh Shetzler, Legislative Counsel for the Family Foundation. We're particularly concerned with those individuals who would be protected under this bill who would send chemical abortion pills out of Virginia. So they would be committing crimes in Virginia that would be completed in another state, and those individuals would be shielded. We know that most abortions now occur through these means and are often very dangerous, and we think those people should be held accountable when they send those dangerous drugs into other states. Thank you.
Thank you. Okay, thank you. Senator, just so we're clear, your bill only protects legal conduct in Virginia,
That's
right?
correct. That's correct.
Okay. Are there any other questions for Senator Favola? Okay. Is there a motion? It's been moved and seconded by Senator Deeds, seconded by Subramanian that we report the bill. Any further discussion? Clerk will open the roll. Who's got both? There we go.
Ayes 9, no 6.
Great. Senator, your bill reports 9-6. You have one more, Senate Bill 16, which is
Yes.
another bill we heard last year as well, right?
That's correct, Mr. Chairman. There is an amendment in the nature of a substitute. If you would be so kind to adopt that.
Senator Deeds moves, Senator Boysko seconds. Amendment nature of substitute. All those in favor say aye. Aye. Anybody opposed? No. He has a proxy.
The difference between this year's bill and last year's bill is I expanded the language so I include not only search warrants but subpoenas, court orders, or any other process that may be used to access menstrual health data, and then I expanded the definition of menstrual health data so it's not only data include on a computer or computer network, but any other way that menstrual data may be contained would be protected. Again, this is personal, private information. Law enforcement really has no business accessing this information. I think it's a common sense bill, and I would think that a majority of Virginians would want their menstrual health data protected. That's my bill.
Okay, thanks. So last year's bill was just the search warrant, and this one applies to subpoenas, court orders, or other types of legal process issued in a criminal proceeding, right?
That's correct.
Okay, Senator McDougal has a question.
Mr. Chairman.
Peake has one too. Yeah.
Mr. Chairman, this one I think is for Mr. Benjamin. Mr. Benjamin, if you had a case where somebody was allegedly killed because they were pregnant, and so they were no longer able to give consent for the information to be released, would the prosecution be able to subpoena any evidence to establish that the person was in fact pregnant?
Mr. Chairman, Senator McDougal, what they would not be able to do is subpoena any information that was used specifically to determine, predict, or estimate menstrual health.
Okay, Senator Peake has a question. You done, McDougal?
Yes, Mr.
Well,
Chair.
I don't think he answered my question, but.
Okay, you want another question?
Mr.
Mr. Chairman, I guess my question is, if
Senator
the person was in the early stage of pregnancy, would that prohibit them from getting that information?
Mr. Chairman, the answer is no.
Senator Peake, you got a question?
Mr. Chair, yes, patron. Again, same as last year question, is the patron aware of any Commonwealth's attorney or anyone in the Commonwealth of Virginia who has issued a search warrant or a subpoena for this information?
I am not aware of any search warrants that have been issued, but of course I never would have predicted the Hobbs decision either. So I am taking a precaution that I think is necessary. If in fact a state were to implement an abortion ban, which our governor and other leaders have talked about rather robustly, the next step to enforcing an abortion ban could be accessing menstrual health data, which is why I'm trying to protect that data.
Mr. Chair.
Senator Peake.
Just follow up to that. I will. From the day Roe versus Wade was decided, it was a national movement to overturn Roe versus Wade. And Donald Trump, when he became president in 2016, stated that he wanted to appoint Supreme Court justices to overturn Roe versus Wade, which was done in Dobbs. So to claim that Dobbs, you could not have foreseen that, is just shocking because it was. But this has never been done in any jurisdiction, and it's just in search of a problem that does not exist.
Mr. Chairman, there are states that are currently considering this legislation.
Okay, any other questions before we go to support and opposition? Senator Stanley.
I'd ask the Senator Favola, but as far as we know, in spite of the Dobbs decision and the Dobbs decision returned it to the states for those states individually to make a decision. Right now in Virginia, there is no ban on abortion. In fact, we have, I guess, assimilated without consideration of what I've seen to be amendments to our Constitution, our state Constitution, that we've reverted back to basically what the Roe decision was, right? 26 weeks?
On our state statute, we permit abortion legally and safely within the framework of Roe v. Wade.
Mr. Chairman.
Senator Stanley.
And looking at the way that our government is right now, I don't see that changing, but are we putting something as a prophylactic in place that may or may not be necessary? I mean, and I guess my question really is there any other reason for prohibiting a search warrant about menstrual cycles? Because I just don't see where this would be relevant in any other criminal law, except on something that's not illegal.
Well, Mr. Chairman, I would just say it's always of value to protect personal information. This is not protected under HIPAA. If the HIPAA law were to change, I wouldn't have to put this information in, but it's not a medical record, so it doesn't have the protection of HIPAA. This is a step towards privacy when we have lots of laws on our books that protect information from being accessed without consent or without due process.
Mr. Chairman.
Okay, Senator Stanley.
But there is no law, there is no other usefulness of such information in any legal criminal case. There's no statute related to this where any of that evidence, if sought, would be relevant. Correct?
Senator Favola.
I will just say, last year there was actually an amendment in the budget that was submitted by Governor Youngkin that would have penalized providers for providing an abortion. And one of the ways you would have implemented that could have been accessing menstrual health data. We're in a different world than we've ever been in before. And this issue has come to me from several constituents who are extraordinarily anxious and nervous, younger women who want the privacy and protection and freedom that their mothers had, and they feel they don't have it. This was a request specifically regarding their personal and private information.
Mr. Chairman.
Okay, thanks. Senator Perry's microphone has turned green.
Yes, Mr. Chairman. I just want to make a few points about this. The first one is that my friends on the other side of the aisle tend to be taking both sides of the argument. I think the first point that was made was that to Senator Favola was that since 1973, when Roe was decided, that we should have anticipated, because people were upset about the decision and trying to overturn it. So this should have been passed many, many, many years ago. And then the second point that was made was, why do we need to pass this now? Abortion is still lawful here in the Commonwealth of Virginia. So I think that's a little bit of arguing both sides of the same coin for why they're in opposition to this particular bill. And I will say that if folks like myself had not won their races, I think that my friends on the other side of the aisle made clear that abortion rights would have been rolled back here in Virginia. If just speaking to the bill briefly, the point of this bill is to protect women's reproductive rights, which, despite the people who wanted to roll them back since 1973, the vast majority of Americans agree with.
Okay. Senator Subramanian, do you have a question?
I don't. I was just speaking to the bill.
We do that after we take testimony.
Sounds good.
Yeah. Okay. So, all those in favor of the bill, come on up.
If there's anyone online that would like to speak in
Let's go
favor,
3 and
raise
3,
your hand.
Okay? 3 and 3.
Denise Harrington, League of Women Voters of Virginia. I appreciate the discussion, but a person's menstrual cycle should never be made public. If a woman is having a health problem, then she and her healthcare professionals should discuss this in private. This is an egregious violation of privacy and government intervention into our private lives. Protecting the privacy of this information is urgently needed. The information stored by digital health apps can be used in court as documentation that a birthing person has terminated a pregnancy. Several states are already considering or have implemented the idea of checking these apps if they suspect a person has had an abortion. Thank you.
Thank you. Come on up. Everybody come on up.
Mr. Chair and committee
walking.
members, Lexi White with Repro Rising Virginia and the Virginia Reproductive Equity Alliance. Protection of privacy is critical in a time when reproductive health care remains under attack. Menstrual cycle trackers are popular for a reason. Nearly a third of American women and folks who menstruate use these apps, according to a 2019 survey published by the Kaiser Family Foundation. These apps have helped make menstruating people's lives easier in many ways, from family planning to detecting early signs of reproductive health issues to making health decisions and planning appointments in relationship to reproductive health needs. People who have periods should not be foregoing these valuable tools out of fear that this data will be used to surveil them or to punish them for pregnancy-related conditions and outcomes. It's also not lost on me that Black and brown communities, LGBTQ plus people, individuals living with low incomes already experience over-surveillance and disproportionate harassment and discrimination in the criminal legal system, and data abuse and misuse can further exacerbate these risks, all in addition to the healthcare barriers our communities already face. Personal, private menstrual data should not be used to incite fear or as a tool for criminalization. We ask you to support this legislation. Thank you.
Okay, 45 seconds. Come on up.
Thank you, Mr. Chair. Tammy Miller Jennings with the Virginia chapter of the National Organization for Women. The fact remains, reproductive rights are under attack. And we're a few races away where the leadership would have been very different. And I strongly believe that there could have been legislation going after this very data. Menstrual data is private. It's not for anyone to know about, hear about, or read about. So I would strongly ask you to support this bill and protect the women of Virginia. Thank you.
Okay, we got 8 seconds left, so name, group, and support or oppose.
Galina Virginia, Birth and Color, support the bill.
Thank you.
Dr. Wendy Klein, I strongly support this bill. It shouldn't be lost on you that all of these people are women coming before you to say, protect our privacy.
Remember the bill was carried by a man last year. Come on up.
Mr. Chairman, members of the committee, Jamie Lockhart, Executive Director of Planned Parenthood Advocates of Virginia, and we support this bill. Thank you.
Monica Hutchinson, President for Henrico County NAACP, and we support this bill. Thank you.
Brianna Diaz, ACLU of Virginia, as well as a non-binary person who supports this bill. Thank you.
Katie Page, Virginia, affiliated with the American College of Nurse Midwives, and we support this bill.
Hello again, Latoila Mathias, Progress Virginia. We support this bill and thank the patron for bringing it.
Gabriela Watson, Latina Institute, Virginia, we support.
Nicole Lauder on behalf of the American College of Obstetricians and Gynecologists, and we support the bill. Thank you.
Taye Mallory, unmute and make sure your camera's on.
State your name, your organization, that you support or oppose.
Virginia NAACP, and we support.
Thank you. Okay, let's reset the timer. Come on up.
If there's anyone online that would like to speak in opposition, raise your hand.
It's me again. It's Olivia Turner, president of VSHL. I want to quickly say this. This is, as Senator Peake suggested, a solution looking for a problem. I appreciate that both Senator Surville and now Senator Favola have brought this forward. It is not something the pro-life movement has any interest in pursuing. We've actually made that absolutely clear. In 2022, a letter was written, signed by over 75 pro-life organizations that very clearly, and I quote, stated, as national and state pro-life organizations representing tens of millions of pro-life men and women and children across the country, let us be clear. We state unequivocally that we do not support any measure seeking to criminalize, punish, or pursue women in any capacity. We stand firmly opposed to include such that would include any penalties in legislation. We will oppose, in other words, any legislation or any action taken by our state affiliates or state bodies that would, in fact, as Senator Favola has suggested, pursue women like myself who are using these apps and data. This is science fiction, and there is nobody on our side interested in using this against the women of their states, their communities, or our country. Thank you very much.
Okay, come on up.
Mr. Chairman, Josh Setzer on behalf of the Family Foundation. I want to remind all the members that a search warrant can only be issued upon probable cause that a crime has occurred. So what we're doing here with this bill is taking away the opportunity of law enforcement to pursue evidence for crimes such as forced abortions and abortions on minors without parental knowledge or consent, issues of forced abortion that involve human trafficking. Those are the only scenarios in which this information could be obtained. And now we're taking that out of the hands of law enforcement. So we think that's a really bad idea, and for that reason, we think you should oppose the bill.
Okay, anybody opposed online?
Mr. Chair, there's no one online to oppose.
Okay, Senator Favola, I don't think you need to say anything else if you don't want. Yeah, Senator Deeds moves, Senator Bagby seconds to report the bill. We good to go, Senator Favola? Okay.
I don't get to vote, but
Okay. You don't need to say anything else. Okay, let's go. Clerk will open the roll.
Ayes 9, no 6.
Okay, your bill report, Senator Favola.
Thank you.
So I'm going to remind the committee we have 18 bills left. Senator Pillion.
I would. This is a very straightforward bill. I know that you just heard that, but I'm just letting you know. I mean it. Mr. Chairman, members of the committee, Senate Bill 725. This bill renames the current Drug Treatment Court Act to the Recovery Court Act to align its name's connotation more with the goals that the act attempts to accomplish.
It's just a name change.
It's just a name change that takes a stigma off of a court.
Okay, so is there anybody who thinks this is a bad idea to change the name of drug courts? Doesn't look like it. Okay, it's been moved and seconded. We report the bill. Clerk will open the roll.
What?
Ayes 15, no 0.
See,
Thank
I
you,
told
Senator.
the truth.
17 bills to go. All right. Next we have Senator Williams Graves, who has fault-based divorces.
Yes, maybe I should bring wine to the evening meetings instead of coffee to the morning meetings. How about that?
You can bring me a beer to an afternoon meeting. Senator Williams Graves brought me a coffee yesterday at 7 a.m. and all three of her bills passed. So,
So I'm bringing wine next time I'm going to come into the afternoon meeting.
all right.
Mr. Chair, members of the committee, Senate Bill 515 is also very straightforward. And it eliminates the one-year waiting period for divorce to be decreed on the grounds of cruelty, reasonable apprehension of bodily hurt, or willful desertion or abandonment.
And Senator, it's my understanding the Family Law Coalition, I think, is here. Is that right? Mr. Lang. Oh, there you are. My understanding is there was some talk about doing a study, a broader study about all the family law fault periods to try to figure out if our old laws need to get fixed over the next year. Is that going on? Right. Right. So, Senator, do you have any thought about your bill being wrapped into this big study that's being done about fault periods and stuff? Because there's lots of other different grounds carried over for
no
you.
problem with that.
Looked at that way.
I have no problem with that.
We carry the bill over.
Okay. Senator Deeds moves. Senator Subramanian seconds. We carry the bill over to 2025 so that it can be part of the Family Law Coalition study. And I will write a letter to the Family Law Coalition asking them to study this issue. Okay. Clerk will open the roll. Yeah, for a year.
Thank you.
Thank you, Senator.
Senator Deeds.
You got Boy Scout. There you go.
Ayes 13, noes 2.
Okay, 16 to go. Senator Durant. School board placements and alternative ed programs. Is that what we got? 444?
Yes, good afternoon. First, I move the substitute.
Okay, Senator Stewart moves. Senator Stanley seconds. Adopt the substitute. All those in favor say aye. Aye. Anybody opposed? Okay, the substitute's before us. Senate Bill 444. Has that substitute been distributed?
Yes, Mr. Chair. It was distributed after the whole packet was, so it might be loose on your desk with the handout from Senator Durant.
All right. All right, got it. All right. Go ahead, Senator Durant.
Okay, thank you, Mr. Chair. This bill provides a mechanism for schools to request information about certain juvenile dispositions that the schools can use to provide supports for students and their families. I do have Lisa Boatwright, counsel for Stafford County Public Schools, who's joining us virtually as a witness for this, who I think she's still in the queue, correct, ready? Are you serious? Yes. Okay, I'll text her.
Senator, you want to go by temporarily while we get somebody back online?
Let me just text her real quickly, and I'll kind of talk a little bit what the bill does and see if I can get her back on.
We got plenty of other work to do.
So I just give her 2 seconds if I will take it by temporarily. The bill provides seeks to provide context for certain juvenile court dispositions already required to be disclosed to school superintendents. And so the current information provided does not always provide useful information for the schools. It typically only states what's been happening, whether it's deferred, convicted, not convicted, with no contextual information. So if conditions are ordered by the court in connection with the deferred disposition, this bill allows the superintendent to make a written request to obtain what those conditions are. This helps the schools to ensure that any necessary supports and interventions are implemented for the student. And school supports can be helpful in order to ensure that students are kept in school and they are not getting into further trouble. Schools want students to remain in school so they can remain on the pathway to graduation, and really seeking to avoid having interruption in their studies that can result in the students falling behind, and which would then turn require students to put in more work to help them catch up, and then in the worst case scenario, them not completing their education. So this is seeking proactive supports to implement, making sure that we're not seeing learning losses getting exacerbated or even falling out. So is she back on, or? No, okay, I guess we're going to have to, if that's okay with you, Mr. Chair, to take it by temporarily, and I'll try to get her back on.
Okay, Senator, if you could do that, and while you're talking to her, I'm going to have some questions about exactly what types of information the superintendent can request. I mean, representing juveniles, I'm not sure I always want the school to know everything, and I don't want them to have just complete access to somebody's file, and I'm just not really clear the full parameters of this, so you might want to talk to her before she testifies. So why don't we go by temporarily on this, and
if it just clarify, Mr. Chair, what kind of information that they can request?
Right. Whether
Okay.
they can access the entire file or what. I mean, with juveniles, we're very protective of the information that's in that juvenile court file, and so
Yeah, I think I have
there
some
might
of
be
the
a
answers.
reason it's limited. So
Yeah,
why don't you
I-
take that up with her, and we'll come back in a sec, okay?
Yeah, I think I do have some of the answers to that, but I would rather she speak to it directly
All right,
on
we'll
it.
come back in a sec.
Okay, thank you very much, Mr. Chair.
Senator Rome, you've got 2. Right?
All right,
Wanna
Mr.
do
Chairman.
292 first?
Yes, Mr. Chairman. Mr. Chairman, 292 has an amendment from, I believe council should have.
You have an amendment or a sub?
It's an amendment. It's short.
Yes, Mr. Chair, that should be distributed to everybody. And the line amendment is on line 41, after respondent, insert following allegations of abuse or neglect.
Okay, Senator Deeds moves, Senator Boysko seconds the amendment. All those in favor say aye. Aye. Anybody opposed? Nobody's opposed. Amendment's adopted. 41. You're on line 41. Okay,
right,
so Senator, tell us what your bill does.
Sure. Well, first I'll tell you what that amendment does, and then I'll tell you the rest of it. So the amendment there, it includes following allegations of abuse or neglect after the word respondent. The amendment is to ensure the intent of the language is clear and that guardian ad litems are instructed to utilize only the information to which they have access, preempting possible future ambiguities. And so, Mr. Chairman, Section 64.2-2003 currently requires GALs to speak to the propriety and suitability of the person selected as guardian by considering a suit of the candidate's qualifications and their circumstances. What SB 292 seeks to do is to include within this consideration whether or not the individual works as a full-time guardian, their expected capacity to serve as a guardian, and that's a big issue that we have in Virginia right now, and whether or not they have been named as a perpetrator in any substantiated adult protective services complaint involving the respondent. And, Mr. Chair, this provision comes as a direct recommendation from JLARC. This is recommendation number 2 from the 2020 review of Virginia's guardianship and conservatorship system. According to JLARC, the current requirements I'll just do the rest of this. Ultimately, this bill seeks to increase the information available to the courts during the appointment of a guardian. These reports produced by the GALs are the primary source of information that judges use to decide on whether an individual will be placed under guardianship. According to the JLARC report, the, quote, current requirements to make those determinations are insufficient. So basically, that's the problem we seek to correct.
Okay, so we're basically directing the court to some sort of more specific guidance about the things they ought to look at in JL reports. So,
That is correct, Mr. Chairman.
okay, and this is JLARC recommendations.
That is correct, Mr.
Okay, is
Chairman.
there anybody opposed to the bill?
Second.
Okay, it's been moved by Senator Carol Foy and to report the bill. Senator Deeds seconds. Clerk will open the roll.
Ayes 15, no zero.
Senator Rome, you have
All right. Thank you, Mr.
321 about journalists.
Yes, thank you, Mr. Chairman. So, Mr. Chairman, this is a jobs bill. It's a jobs bill for former UVA Cavalier Daily editors-in-chief. And SB
I know one of those.
Yep. SB 321 will strengthen our current SHIELD law that you may recall, Mr. Chairman, we passed in 2020. This does a little bit of cleanup to it with 4 very short, simple words. HB 113 back then ensured a news person engaged in journalism shall not be compelled by the Commonwealth or locality to testify about, disclose, or produce protected information with certain exemptions in criminal proceedings only. This adds administrative and civil courts to that as well. So that's the bill. That's the bill in its entirety.
Senator, here's my question about the bill.
Sure.
As soon as you add civil stuff, you get in like a defamation case, right?
Mm-hmm.
So would this mean that that they couldn't compel a news person to testify in a defamation case?
So, Mr. Chair, I would refer on this that they still have the ability here. If you look under Section C, where it goes into 1, 2, 3, and 4, if you fulfill those requirements, you would still be able to have that testimony in that case. So basically, it's just making sure that what happens in civil proceedings is following the same thing that they do in criminal proceedings, and which we currently have. Beyond that, Mr. Chair, I would defer to counsel to clarify.
Actually, let me ask Taylor. So this statute doesn't apply to civil subpoenas, right? This is only in a criminal proceeding because it's a 19.2, right?
Mr. Chair, this section
Only applies to criminal.
Yeah, only applies to criminal.
Yeah. And hence the reason for the bill, as I understand it, Mr. Chairman.
Yeah, okay. Got it. Okay. Is there anybody opposed to the bill as Senator Boysko reaches for a microphone?
Is there anyone online that would like to speak in opposition?
And Mr. Chair, I'll also note that my former boss is online to speak in support. He's actually been jailed as a reporter, so he's got a lot on that. Is he on Brian Karam? Brian Karam?
Is he in support or opposed?
Brian, you may unmute
probably-
and please make sure your camera's on.
You want him to speak?
Yeah, he's been waiting for a while.
Okay, why don't we set it at 2 minutes, 2 and 2?
Just 1 minute is fine.
Go ahead, sir.
Hi, thanks for having me on, and I'll just say briefly that as a charter member of the Jailbirds Club, which is a group of reporters that have gone to jail to support First Amendment, this is an important part of of your law that you passed previously, because anti-SLAPP legislation and other legislation keeps large companies from holding reporters responsible monetarily when they can't put them in jail. So this is important to especially small community newspapers, which I ran for many years. It's also important for young reporters coming up who want to stand by and do their job. So there is not a civil penalty that is actually sometimes worse than spending a night in jail.
Okay, thank you. Again, there's nobody opposed out there. Nobody opposed online? Okay, Senator Boysko has a
Mr.
motion.
Chair, move to report.
Here's Senator Boysko moves. Senators Carol Foy and Sue Romanian second. That we report the bill. Any further discussion? Nope. Huh? No further discussion? All right. Clerk will open the roll.
Regular calendar.
Ayes 12, noes 3.
Bill reports, Senator Rome. I think that's it for you, right?
Thank you, Mr. Chairman.
Okay, Durant, you ready yet? Doesn't look like it. Okay. Are you ready yet? Okay, she's still not ready yet. Stanley, you ready to do yours? We heard last time? Why don't we go to Stanley's 95?
Mr. Chairman, members of the committee, you've seen this bad boy before, but went to go do some homework, and I think Mr. Chairman has the most simple way of handling this amendment. We looked at some other ideas from some people that wanted to be involved, but this Senate Bill 95 does a very simple thing. In Virginia Code 18.2, 267A and F, it provides that a law enforcement officer shall, upon request, allow a driving while intoxicated suspect to observe the analysis and results of a PBT, what we call a preliminary breath test, and that the officer shall advise a suspect of the right. So when the officer doesn't advise the suspect of that right, there's nothing, and we've had a court case which says it's not excluded. So what this bill does is say that we are going to provide a remedy if a law enforcement officer refuses to comply with these statutory requirements, and that basically is an exclusionary rule for matters of suppression.
Right.
If
Senator,
there's a
I
matter,
think you explained this last week.
Yeah, probable cause.
On
I just
Monday.
love to talk.
Okay. Well, I think the chairman had some amendments to help your bill, if you'd like.
Mr. Chairman, I would love, for once in my life, I would love when you amend my bill.
Okay. Taylor, could you report the amendments that I suggested?
Yes, Mr. Chair. It would be on line 36, we would be striking adequately. Line 38, strike adequately. And then on line 39, after admissible, insert in any motion to suppress.
Thereby increasing my feelings of inadequacy.
Does anybody want to move my amendments, Senator Deeds? Okay, Senator Perry moves, and some people down there second. The amendments, all those in favor say aye.
Aye.
Aye. Okay, the amendments are adopted. Now, Senator Stanley, your bill is amended. Is it cleaned up good?
Mr. Chairman, I would advise everybody on this panel, it's cleaned up real good.
All right.
You can take it out to dinner.
Okay.
And I think that's a simple way of doing it. It's really,
The admissibility of the PBT is only for determinations of probable cause. If you file a motion to suppress, that can be used to determine probable cause, but if they haven't advised them of the rights, then they shouldn't be able to use it in the matter of probable cause.
Okay, Mr. Benjamin looks like he has questions about the language.
The only thing that I think would help the bill, Mr. Chairman, is if you permitted the accused to use the test results if they wanted to. For example, if the PPD is a .03 and the defense wants to use it to show the absence of probable cause, then I think that's an instance where the patron may agree the defense should be able to use the reading.
I mean, Mr. Benjamin, in more enlightened jurisdictions like Fairfax, a lot of judges already allow that, but we might have to put that in the code to make sure the unenlightened jurisdictions do not. What do you think?
Well, my chief co-patron, Mr. Chairman, I'm with it if you're with it.
Okay. Can you scribble out a sentence? I think that we can approve in concept right now.
We can do that easily.
Okay.
Yes,
so Senator Steeds moves, Senator Stanley seconds an amendment in concept that the accused person can introduce the result in any suppression in any proceeding?
It would just read, Mr. Chairman, on line 39, shall not be admissible by the Commonwealth. I think that would fix it.
Okay. All right. All those in favor of the amendment say aye. Aye. Anybody opposed? No. Okay. Does anybody have any comments on the bill after we've done some work on it? Mr. Dix.
Good afternoon, Mr. Chairman. Mark Dix on behalf of the Virginia Trial Lawyers Association. I'd like to say our thanks to Senator Stanley, our good friend Senator Stanley, for introducing that on our behalf, and we hope that you will report the bill. Thank you.
Okay. Does anybody have any problem with the bill as it's been amended? Doesn't look like it. Okay, it's been Senator Dees moves, Senator Aird seconds that we report the bill. Clerk will open the roll. We got a roll? Yeah, open the roll, yeah.
Ayes 15, no 0.
All right, we're making progress on this docket. Durant, you ready yet? Doesn't look like it. All right. I know. Is Suderline here?
He's sat here for like 2 hours.
You better come back.
Is there a motion?
Okay. Yeah, okay. You know what? Senator Carol Foy actually signed the sign-up list, even though she's on the committee. So okay.
She's hoping to escape.
So, Carol Foy, why don't you do your? You got 3? No, just 1, right? It's the one we kind of. Yeah, right. It's a complicated one we deferred from last week. So why don't we do 144? This one's a little tricky.
I had easy ones, not tricky ones.
What's yours?
Mine's like days of the court.
Oh, yeah, the end.
The clerks, all the clerks are sitting out here waiting for Ryan.
Oh, yeah, can we get some clerks out of here, Carol Foy?
I'm sorry?
Can we get some clerks out of here? There's some people waiting to hear one. Why don't we do McDougal 736?
I got witnesses too.
Oh, you do? Okay.
Clerks of the court. I got their back. And they know it.
Are you sure this is easy? This is one where they want the clerks want to shut the court down instead of the judge, right?
Mr. Chairman, I think it's going to be a straight decision point, but I think Senator Openshain did indicate there are a number of clerks here from the circuit courts, but I think there were some suggested amendments. I don't think there's peace in the valley, but I think that some of the amendments made the Supreme Court less unhappy.
Okay, hey MJ, can we get the right bill up? We're going to do 736 first. And Senator, have your amendments been distributed?
No, I think after conversations with the OES and the clerks that gave them to staff this morning.
Yes, Mr. Chair. So the suggested amendments would make Senator McDougal's bill identical to the House version, which is HB 1396. So on line 24, After clerk of, you would, oh, this is a technical amendment, I'm sorry, strike the and insert the. That was just a little technical amendment. And then on line 36, we would strike all of lines 36 through 41. And then the rest of the bill would stay the same. So essentially, the struck language on lines 36 through 41 would take away any language authorizing the judge to close the clerk's office.
I'm sorry. What was the last thing you said, Sabrina?
Sorry, it would remove any of the remaining language authorizing a judge to close the clerk's office. That was inadvertently left in, I believe.
So in other words, the closure of the courthouse will now be 100% up to the clerk instead of the chief judge of the circuit court, right?
That's correct, Mr. Chair.
Can't close the clerk's office.
Oh.
I'm not sure.
No?
Sorry.
The clerks don't seem to agree with me.
Okay.
I think it's the clerk's office.
Clerk's office.
Not the courthouse. The clerk's office.
Got it.
Oh, I'm sorry, Mr. Chair. I misheard you. Thank you.
The clerk's office. Okay.
Mr. Chairman, I think the issue becomes district courts are controlled differently than circuit courts. As the committee is aware, circuit court clerks are constitutional offices, and in different jurisdictions, it depends on how your court runs, whether they go with county supplements and they run on the same schedule as the county, or district courts and circuit courts could be in different directions. And this would give the constitutionally elected circuit courts authority to make decisions about their offices closing around certain times, like around holidays.
Right, but also for like inclement weather, though, right?
And inclement weather.
Okay.
Mr.
Senator
Chair,
Deeds.
I'm hoping that somebody is here from the Executive Secretary's office
They are, Mr. Chairman.
to let us know what the court thinks of this.
So, Mr. Chairman, maybe we could, I don't know that the Executive Secretary's office loves this, so maybe we could hear from a clerk first and then the Executive Secretary. Who's talking?
All right, why don't we set the timer at 2 and 2. Okay. Mr. Hopkins.
Mr. Chairman, members, Carlos Hopkins, Gentry Lock with the Clerks Association. Just very briefly, it does not give the clerks the unlimited authority. Within the language of the bill, it's still tied to an event. For example, in the first paragraph, if the locality, through resolution or other means, authorizes the closure, then the clerk would be authorized to close the office as well. Paragraph 3, which I understand from OES was a concern for the judges, we unstruck the language that had been in the original amendment to address those concerns. So in the cases of inclement weather, et cetera, under that paragraph, it would still go with the presiding judge. The remaining paragraphs describe holidays such as Christmas Eve, which for all of us who practice, the courts are closed anyway. And then the final paragraph would insert the language of the Supreme Court, the governor, or the Judicial Council in authorizing the closure if state offices are closed pursuant to one of those authorities, then the clerk could close their office as well. And so the language is still tied to some event from an authority. There was a question I received in one meeting as to whether or not the clerk could close for any reason whatsoever, but the language doesn't address that, and that's not what they were seeking. It would also allow the clerk in certain circumstances to open on Saturdays for administrative purposes. That is something that in some of the jurisdictions where they have multiple or have satellite offices was important to the association. And then finally, I would also note that within the context, we left in the language regarding Code Section 1-210 so that when the office is closed, it still acts as a legal holiday, which for purposes of tolling will continue to operate as it always has. So it does not affect the filings for persons if the office is closed because it would be treated as a legal holiday as it currently is in the statute.
Okay. Anybody else?
Yes, sir. Randy Carter, Clerk of the Circuit Court of the City of Suffolk from the Virginia Court Clerk Association. We wanted this because there seems to be a split. Different judges look at it different ways. Some judges say we can do it. Some judges say we can't do it. And we just want it unified across there. But we took out the inclement weather thing that's still the judge's prerogative.
Okay.
Mr. Chairman, just to be clear, I don't think we reported that. There's lines 24 to 29. All the existing language would be reinserted and the new language would be eliminated. So that would go back
not
to
just the language on line 24. No, the.
Correct.
I think the was the only amendment we
Did we adopt the other amendment?
We did. So Senator McDougal moves, Senator Deeds seconds that we restore lines 24 to 29 to its present, all the present language, right?
So, Mr. Chairman, so then to be clear for the committee, you have paragraph 2 and paragraph 4. So paragraph 2 is Christmas Eve, and paragraph 4 are days that the governor has declared a holiday or state employees or portion thereof, or the Supreme Court or Judicial Council.
Sorry, so what is exactly is the amendment we need to do?
We need to reinstate the language in paragraph 3.
Yeah, Mr. Chair, and I just want to ask one clarifying question. We're also retaining the new language, correct? No, we're restoring it exactly as it is. Okay, that's correct. Okay, thank you.
Mr. Chair, as I understand the amendment, paragraph 3 will be the existing language. We strike
Correct.
the new language, we unstrike the old language. Correct.
So,
Okay. Okay. We already did one amendment. Anyway, all right. So Senator Deeds moves to restore paragraph 3 to the way it was, and Senator McDougal seconds that motion. All those in favor say aye.
Aye.
Aye. Anybody opposed? No. Okay. So
Mr. Chairman, you have 2 and 4 are left. So you have on when county or cities close, then the clerks can close in 2, and on 4, when the governor, Supreme Court, or Judicial Council authorizes holidays.
Okay. Is there anybody opposed to the bill as it's been amended? OES? You're still opposed?
All right. Yes, sir, we are. Rachel DeGrava, Office of the Executive Secretary of the Supreme Court. As was stated earlier, this would give the clerks the ability to close the courthouse because it's cross-referenced in 17.1, 705.2, which says that Judicial Council can determine the days that Circuit Court is open, and it's subject to this provision that we're talking about in this bill. So the days in this bill close the courthouse, and so I think, for starters, that was just a philosophical difference between the judges and the clerks. I'm not sure that's something that can be resolved. I certainly understand they are constitutional officers, but I do think this is a unique position in the sense that the constitutional officer is also the custodian of records, which are the documents that the court needs to do its business. So it's a little bit of a strange combination here in terms of all of these folks in one building. The way current law is structured is you have the district court judges under 16.1 have the ability to close the courthouse, and they are required to coordinate with the circuit court judge of that area to determine what is going to happen for a closure so that everybody's all on the same page. This would make it so that those are no longer consistent because the clerk would be independently making that decision. The other concern that our judges had with this was, the basic issue is structure. We have constitutional officers, we have local holidays, we have state holidays, we have holidays that are declared in code versus holidays that are chosen by the governor, and all of these folks are making decisions about who's going to be open when. And the problem is, I'm not sure that's something that can be solved with this particular bill. I've tried my best in the last 2 days to come with whatever language that would be. We're happy to continue this conversation, but we were not aware of these concerns. They were not brought to OES prior to this bill being filed, so we're doing our best with what we got. My understanding is some of these arguments have been going on longer than I've been alive, so I'm just doing my best to try to resolve some of those. And I'm also happy to answer any questions.
Okay, thank you. Is you opposed? No. Okay. Hold on. Well, hold on. We're kind of in a never land here in terms of process. So what's the sense of the committee and what we're going to do with this? More constitutional office disputes. Senator Perry?
Mr. Chairman, with all due respect, I don't think it's a constitutional office dispute so much as it is the clerks of the court want to be able to close their office when other constitutional officers have closed their offices, right? So when the judges, or who are not constitutional officers, when the judges, say, hey, we're not here for today, right? Should the clerk's office be required to then stay open? Or the Commonwealth Attorney's Office, for instance, can decide they're not going to be there, right? They're not going to be there. But guess what? The clerks can't make that decision for themselves. I don't think it's so much a debate amongst them or a fight between them. I think it's just trying to put the clerks on par that, hey, we don't have to be here working on days whenever no one else everyone everyone else has decided it's not a good day for us to be working because it's a holiday that we want to recognize or whatever else. And so I guess policy-wise, I support that.
Okay. Does anybody else in the committee have a view? No.
I'm going to stick with my constitutional officers.
All right. Okay. Is there a motion? Okay, it's been moved to report the bill as amended. All those in favor, enter your votes here in the, open the roll, please. What's going on?
Ayes 14, noes 1.
All right. Okay, your bill reports, McDougall.
Thank you.
It looks like Durant is back with her witness, and then Suderline has arrived.
Again.
So Durant has a witness online.
Thank you so much, Mr. Chair. And if you'd like me to, members of the committee, to recap what I just kind of gave as a summary of what we're seeking to do, or if we're in a good posture, I'll go ahead and have her come in and weigh in.
I'm going to find that bill again.
This is Bill 444. Yeah. So it's a
Right. So you're trying to get more information to your superintendent.
Correct.
You had a superintendent that wanted to explain the problem they had.
It's actually the council for Suffolk County who's requested this.
It's what?
So council, her name is Lisa Boatwright. She's council for Suffolk County who's.
Okay,
that's the
she's now
requester.
online?
Yes, sir, she is.
Okay, can you get Ms. Boatwright online and have her explain what problem we're trying to solve here?
Okay, can you all hear me?
Yep.
Okay, Mr. Chair, members of the committee, first of all, I want to
Make sure your camera's on, ma'am.
Okay, it should be on? It should be on now.
There, you got you.
Okay. Mr. Chair and members of the committee, thank you so much for indulging me with this technology issue. When technology acts up, it really does it really big time. So the problem that we're trying to solve, we already get certain juvenile court dispositions, but the information is very cryptic. So we'll get things like deferred disposition. Okay, deferred dispositions typically come with some types of conditions. And so it's two things. Number one, when students when they're coming back to us, if they've been out, and there are certain conditions that are attached, we would like to be able to put interventions and supports in place to assist these students. Right now, we don't get any information. But the bigger problem is on when we get certain criminal charges that are required to be reported to us, and they may be of a serious nature such that we have, as allowed by statute, after having the opportunity to speak with the parent, decide to place the students into our Phoenix Center for Innovative Learning. So that is one of our alternative education programs. When the student goes to court and they have a deferred disposition, we know that there are conditions to that, but we don't know what they are. So we don't have the information that we would like to have to be able to talk to the student and the parent and the administrators and make a decision, because the student more than likely is able to go back to their base school. Sometimes the parents give us the information, and when we see it, we're like, oh, okay, they can just go back to their base school. But sometimes the parents don't give us the information, and we can't get it any other way. So we don't have information to make decisions. And once we have them, sometimes all students need is to be able to have a counselor or a safe person to check in with them to make sure they're meeting the conditions, so that when they go back to court, they're able to say, hey, you know, I have my counselor, I have my school administrator, and I've been doing well. Because the idea for us is to be able to be proactive with kids, to keep them in school and help to keep them from making poor choices. Because really, When students are absent and they're making poor choices, it doesn't help them with their learning. But right now we get information that's very cryptic. It doesn't help us any. We're like, what is this?
Okay, thank you for that.
Yes.
Is there any questions? Senator Aird.
Thank you, Mr. Chairman. Senator Durant, just to be clear, would this be for any type of charge, or is this limited to certain types of charges that this information is requested to be shared for?
Mr. Chair, I'm going to defer up to council to refer to that one to make sure we're clear.
I think Ms. Boatwright, I think she's deferring to you.
Okay. Yes, sir. Senator Aird, there are only certain types of dispositions that are reportable and that we get, and those are set forth in the statute. Generally speaking, they are for more serious crimes. We don't get dispositions for every time a student is charged with something. We don't get a notification. We don't get all of those dispositions. They match up to the ones that are classified in the statute as reportables to the superintendent.
Mr. Chair.
Senator Aird.
And so that's existing, and this would make it so that it could be any?
No.
Oh, reverse.
What? No.
Okay, thank you.
Okay.
Okay. There are
Can I
other
ask a-
questions. Senator Perry.
Can I ask a question? And I don't know if this is for Senator Durant or for your witness who disappeared.
I should be still on.
Okay, great. I just can't see you. So out of curiosity, would it include things like if a student was not to, as part of their deferred disposition, was not to have contact with another student in the school? Would that be something, a no contact order that might be relayed in this manner that you all might not otherwise get?
That is correct. And we would like to be able to keep students apart to the extent possible. But if we don't get that information, we don't have that information.
And Mr. Chairman, if I
Senator
can follow
Perry.
up. And just a follow-up question, could it also include things like sometimes kids are ordered as part of a deferred disposition to not use their electronic devices outside of for their schoolwork, for instance. And my kids at least have their electronic devices all day, every day in schools. So would that be the kind of thing, if that were included in a deferred finding disposition, that you all might want to be aware of at school, that they're not supposed to be playing games or other things on their tablets or whatever at school? Their computer at school can only be used for schoolwork, even if that may already be the rules, but I know loosely enforced in some schools.
That type of information certainly would be helpful, because then we could do something alternative to help the student.
And if I understand correctly, Mr.
Senator
Chairman.
Perry. We're not in court. Go ahead.
I went through the chair.
All right. All right. Yeah.
Thank you.
So good. Keep going.
Mr. Chairman, if I understand correctly, this information, I understand wanting to protect kids and their privacy. I absolutely do. I just want to make sure that we have had, some issues in Loudoun County Public Schools with information that's being shared with the school, and wanting to make sure they have the information they can do they need to make sure that the kids are treated appropriately and all the kids are kept safe. And so my question was just, you're saying that it can help you all with placement if you have a little bit more information about what restrictions are court placed on that student. Is that fair?
Yes.
Thank you. Thank you, Mr. Chairman, for your patience and generosity.
Mr. Chair.
Senator Boysko.
Thank you. Question
no problem.
for
Always happy to be generous to you, Senator Perry. Go ahead, Senator Boysko.
question for the council. I'm wondering if this legislation undoes something that we had been working towards to stop the school to prison pipeline over the past few years. I know that we had worked over the past several years, probably before Senator Durant was here, to try to really help protect students more and to put more guardrails on the kinds of information. So if Mr. Benjamin might be able to just clarify if he knows, that would be helpful to me.
Mr. Chairman, Mr. Benjamin was not paying attention to this bill. sorry. Did you call?
No. Yeah, Mr. Chair.
There's a question, I think, to council about whether or not this plays into our efforts to stop the school to prison pipeline. I'm not sure it's a legal question, but it's more of a policy question. I'm not sure it's a legal question.
I understand, Mr. Chairman, the overarching concerns that have been expressed during the hearing about the totality of juvenile history information being made available. And I endorse that concern, if that helps.
Okay, Senator Boysko.
Thank you. And as Senator Perry mentioned that Loudoun County had some issues, I feel 100% confident that we have taken steps to.
I'm not sure if that's Mr. Chair.
Hold on, who's that a question to? Senator Durant or council?
Mr. Chair, I just want to clarify. I'm not sure if the senator
Hold on, Senator Durant. Well, I'm trying to figure out where we are. Who are you asking?
Mr. Chair, I just want to make sure before I support the bill that we are not undoing something that we've been working towards.
Okay, who are you asking?
I don't know that Senator Durant has the answers to those questions.
I'm going to vote against.
Okay.
Yeah, Mr. Chair, if I can, I just want to clarify. I'm not if I understood your voice. I'm not sure if the senator from Loudoun has got concerns about this or clarification on that.
Okay, Senator. Here's where I think we are. Okay, these are records that are normally sort of rationed out for a reason because there's a lot of very sensitive stuff that's contained in a juvenile's file. And just because somebody wants it doesn't mean they should necessarily get it. And there can be lots of different reasons why somebody might want to tap it. And we typically leave the discretion about who accesses these records in the hands of a judge. That's typically what happens. There's also, I think, an inconsistency between the first statute and the second. If you look at the first one, it says that the clerk has to provide a copy of the disposition order to the superintendent. The second one seems to want to, I guess, get around some Dillon rule problem, and it authorizes the superintendent to make a request, but it says the superintendent can request the disposition and any other relevant information, which means anything, which creates ambiguity about exactly what they're allowed to get. Because you got one statute says they can ask for anything they feel like is relevant. The other one says they can only get this. So there's an inconsistency between the two, and it also runs counter to the policy about judges controlling the information. I think that's what's causing the consternation. And Senator Deeds looks like he wants to say something.
I was just going to make that last point you made. It cuts the judge completely out of the process.
Right, it does.
The judge is typically, under the law, the guardian of the judicial record, and this cuts him or her out.
Okay. So, is there anybody who's opposed to the bill? Why don't we set up a timer on this? We've had a lot of talk in favor of the bill. Why don't we? Looks like we had somebody opposed to the bill. Yeah, let's go with 2 minutes. Well, given the support, a lot more than that.
Good afternoon. Monica Hutchinson with Rise for Youth. And so for many of the reasons that were already spoken, yes, we are absolutely concerned about this bill leading to from school to prison pipeline issues to also discrimination happening within the schools. We do protect our children's privacy. We do take it very seriously. And so, like I said, there's not really much that I need to say other than like this is not a good bill. So, like I said, we really hope that you oppose this bill. Thank you.
Okay, Senator Jordan has a question.
Can we have the young lady that just testified to come back up? I had a question.
Okay, stop the timer. Oh, you got it.
Thank you, Mr. Chair. I'm not familiar with your organization wholeheartedly, but you said we protect children. What does your organization do, and how do you protect children? I'm just asking because I'm unaware.
So I work for Rise for Youth. Rise stands for Reinvest in Supportive Environments for Youth. And at the end of the day, what we do is we work to end youth incarceration by taking a more community-centered approach to our young people. So, yeah.
Follow-up question?
Okay, go ahead, Senator.
I'm just trying to frame what you all do because I'm unaware. Mr. Chair, do you offer counseling services in schools?
We are not counselors.
Or do you have partnerships inside
Senator,
of schools?
So what does this have to do with the bill?
I'm just asking to qualify your testimony because I've never heard of the organization. That's all, sir.
Okay. Okay. I can tell the Senator I've worked with this organization before on legislation in prior sessions, so you can probably, you can meet with them after, Google it, but we need to focus on the bill. So,
Thank you.
Is there any other questions or thoughts about the bill? No. All right. Is there a motion?
Can I just ask one?
So, Senator, wait a minute. Senator Perry, you had something?
Mr. Perry, can I, Mr. Sirvel, Mr. Chairman, can I?
Yeah.
Can I ask one more question?
Sorry? Question, go ahead.
Yes. Senator Durant, the statute provides notification to the superintendent of deferred finding disposition being entered or something like that. That's on 16.1.305.1. The clerk shall, within 15 days of such action, provide written notice of such action to the superintendent. Those are lines 19, 20, 21. I guess my question goes back to what was provided earlier. Once the school has notification that there has been a disposition, what is it that stops them from going to the court and asking the court for any terms of the disposition that may be relevant to them?
Yeah, I would love to. I don't know if our council is still on the process with that. I don't know if she's Ms. Boatwright. She's still on.
Yes, I'm here.
Did you hear Senator Perry's question? Did the process? You
Yes,
can go back to the court to get the information.
Grant, hold on. I think the question is, is there anything that legally prevents you from making a request to the court to get what it is you're seeking?
That's correct. That's my question.
Mm-hmm.
Mr. Chairman, I don't know the answer to that, but I can suggest an amendment that achieves the same effect. If you look at line 57, after the word request, insert upon a showing of good cause, and then strike intake officer of the court services unit and replace that with court, so that it is a judge who is receiving the request and determining whether good cause has been shown for the release of the specific additional information that's requested.
That's very.
What line?
So Mr. Benjamin, can you read the entire sentence as you would write it?
That's just a copy of the court order. The complete sentence, Mr. Chairman, beginning on line 54, would be the division superintendent may, upon receiving written notification of the offense and disposition of the court pursuant to that code section, for any student who is charged with an offense listed in blah, 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 and who is required to attend an alternative education program, request, upon a showing of good cause from the court in which the disposition was entered, and the rest of it deals with additional information. The first part of the bill deals with the court order.
Right. Mr. Benjamin, I understand that amendment, but I don't do a ton of juvenile court work, especially serious juvenile felony work. And my concern is whether there might be things in the court order that a judge might not want the superintendent to see, which is why they're probably rationing the information out to begin with.
Absolutely correct. I was just trying to help with the bill to achieve the patrons.
I got it. But Mr. Benjamin, the first change in 16.1305.1 and lines 23 to 25 give the court zero discretion and the clerk zero discretion about whether to turn over that piece of paper that the judge might want them not to see.
Agreed, Mr. Chairman. And over the history of this committee, the committee has dealt with numerous exceptions to the confidentiality of this information. And this is another instance where a laudable need is being articulated, but the concern of the committee has always been protecting the confidentiality of juvenile history information.
Okay, well, before we get to your amendment, is OES trying to say something? You're sitting there poised like you're wanting to speak. You gotta get on the microphone because we have to be on the record here.
Yes, Mr. Chairman, Sandy Harrison, Office of the Executive Secretary, Supreme Court of Virginia. We've worked with Senator Durant on her bill and have appreciated that opportunity. Strictly with respect to Mr. Benjamin's suggestion, it would seem to align with the process that is found in 16.1-305. I believe it's D. D as in David. If I don't have it in front of me, I haven't looked at it in a few days. but that would authorize a person with a legitimate interest in a case involving a child to file a motion. I will say that when it has been expressed to me that there have been concerns about docketing such a motion in the courts in this area, and that certainly the Office of the Executive Secretary would be willing and well advised to work with the courts in the area on the docketing delays for these cases. And so there is already a process in place, but we had worked with Senator Durant in order to streamline a process in response to the concerns of the superintendent and Ms. Boatwright. But there is a process that says the information is available upon the granting of a motion by a judge for information from the court file. Does that help with it? Anyway, if anything else might help, here I am.
Thank you so much.
Thank you.
Yes.
I think Mr. Benjamin has another suggestion. Mr. Benjamin was going to suggest that we change shall to may on line 23, but Mr. Benjamin, that gives the clerk discretion, not the court. I mean, shouldn't it lie with the court instead of the clerk?
Mr. Chairman, you're right. I missed that. It should not be the clerk then. It should be the court.
Okay, so I think Mr. Benjamin's suggesting to clean this up and leave the court as the gatekeeper on this, that we, on line 22, strike clerk of the, so it just says the court, and we change may to shall on line 23. And then we make the amendments he previously suggested on lines 56 through 57. Right? And that would leave this in the hands of a judge and a showing of good cause, right? Okay. So anybody want to move those amendments?
Oh, move the amendments.
So Senator Perry moves, Senator Boysko seconds those amendments. All those in favor say aye. Aye. Anybody opposed? Okay. Now we have an amended bill in front of us that requires them to go to get permission from a judge.
Move to report.
Second.
Any further discussion? Okay. It's been moved and seconded. We report the bill. Clerk will open the roll. I'll put a yellow light on it. So,
That was easy.
oh, yeah.
Senator Subramanian for D.
Yes. Suhas is yes. There we go.
Okay, thank you very much, Mr. Chair.
Ayes 15, no zero.
We'll send you a bill. Thank you, Senator Durant. Senator Suderline has been in and out and waiting and back.
We almost killed your bill 7 times.
438.
Thank you, Mr. Chairman. The bill is Senate Bill 438, and I believe council has some line amendments already.
Council, have those been distributed?
Yes, Mr. Chair, they have, and they'll be posted online shortly. I can explain them if you like.
Why don't you, we have them in front of us. Why don't you explain what they do?
Yes, Mr. Chair. First, they strike all of the new language that was added in the introduced bill. And then it changes to say that these commissions will now be composed of at least 2 members from each participating political subdivision. Current law is at least 1 member from each. And then goes on to say that one of those 2 shall have a background in law enforcement or corrections. And then accordingly, because it increased it from 1 to 2 members from each locality, it then changes the minimum membership from 3 to 6 on line 14.
Okay, Senator Deeds moves, Senator Boysko seconds the line amendments. All those in favor say aye. Aye. Anybody opposed? No. Suderline, explain your bill as amended.
Thank you. Well,
does
you
what she
just heard
says.
the bill.
Yeah.
So briefly, the issue we're trying to address is several jurisdictions simply send financial people exclusively. And so we've had some in which every member is someone there from a financial perspective, and that's been it. In other parts of the Commonwealth, that's not the case, but I think that every jurisdiction that's invested in this needs to have someone from a law enforcement or corrections background there. I would hope that they would choose to send someone from the sheriff's office or a similar situation for them, but it's up to them what they want to do. It just has to be someone with that background so that we actually make sure that it's being the board that's got responsibility for it has law enforcement and corrections folks in those conversations rather than folks simply looking at it from a financial perspective, which has created problems out my way.
Okay, Senator Deeds has a question.
Tell me why I've heard from the Rappahannock Juvenile Detention Commission and the New River Valley Juvenile Detention Commission, which is out your way, why they're opposed to this legislation then?
Well, I feel a lot like Senator Locke since this bill's been public and I haven't heard from either of them.
Okay.
And I've been in this room for a few hours, and if they're here, I don't know why they haven't come and talked to me.
Okay.
So I can't answer the senator's question.
Okay. Is there anybody here in opposition to the bill?
If there's anyone online that would like to speak in opposition, raise your hand. Mr. Chair, we have one person that would like to speak.
One electronic hand raised.
Great.
Aaron, you may unmute, and please make sure your camera's on.
Good afternoon, Mr. Chairman and members of the committee.
Hey, MJ, why don't we set it at 3 minutes? Go ahead, ma'am.
I'm Aaron Maloney, Superintendent of the Northwestern Regional Juvenile Detention Center in Winchester. We are a regional facility serving 6 jurisdictions. I oppose SB 438 requiring members of my commission to have a background in law enforcement. Our commission is made up of county administrators, finance, community members, board of supervisors, members of city council, and law enforcement. The diversity is crucial in making well-rounded, well-informed decisions in managing our center. Our focus is on providing quality services in an effort to rehabilitate our youth. If this bill passes, we would be limiting our resources and putting more strain on our already taxed law enforcement community. Please do not pass this bill. Thank you for your time today.
Thanks. We got somebody present in person. Come on up.
Mr. Chair and members of the committee.
Lean into that mic or straighten it out.
It's just me. My name is Carla White. I've been here all day.
Okay.
And I am the superintendent of Rappahannock Juvenile Center, and I'm representing the Rappahannock Juvenile Detention Commission. We serve Stafford, Spotsylvania, King George, Orange, Madison, Louisa, and the city of Fredericksburg, all of who oppose this bill. Our commission has been in existence since 1971, and that particular commission merged with the Piedmont Commission. So this bill would challenge our service agreements. We're not allowed, per that agreement, to have 2 representatives because of the size of the localities that are involved. And those agreements go back, and they have legal agreements that have been through the courts in '78, which merged the Piedmont Commission with the Rappahannock Commission. So we feel like it can get extremely difficult to run if we have to do this way. We've never had any problems. We have people with various backgrounds on our commission, and it works for us because they don't just focus on law enforcement. They focus on our operation. They look at our financial, they look at our books, they make sure we're operating appropriately with HR, with the other jurisdictions. They pay me to do the law enforcement. I have 30 years of experience in the system between DOC and DJJ. DJJ is our regulatory authority, so they make sure that we follow all rules and laws that are set forth by the state. So I'm not sure what the purpose of this law is or this change is, but I would suggest that they address that in their locality because I'm sure that they could work it out and determine who can sit on their own boards. Oh, one other thing, I do apologize. I also sit on the executive committee for the Virginia Juvenile Detention Association. Collectively, we also oppose this bill. It is comprised of 24 detention centers, 12 of which are commission-based. And many of you have commission-based homes, too. I'm not sure if you all realize it. I would hope that you do. But, yeah, so it would affect everything we do. Thank you.
Hey, ma'am, by the way,
Can I ask a question?
Senator Deeds has a question for you, and I got a comment. Go ahead, Senator Deeds.
you don't know whether anybody in your group talked to Senator Suderline about his bill?
I'm going to say no, because we got, and first of all, I've been here all day. I don't know who you are. I apologize. And it's really hard. Well, yeah, but I wouldn't know you to really see you. I mean, don't take that the bad way. But I will tell you, you've not reached out to any of the other homes at all. And we were lucky to know that this bill was in existence. We were notified by DJJ. And they said, hey, you guys need to get in front of it. That's the only way we knew. So.
Mr. Chair.
Okay.
And also my counties are also objecting. I think the city of Fredericksburg sent something.
Okay, hold on. Senator Peake has a question for you, I think.
Is there a group that doesn't oppose this bill?
And I will, even to go further, because I'm a talker sometimes, and I apologize, it also affects residential homes and group homes, which are therapeutic in nature.
Okay, hold on. We got 3 seconds. Senator Obenchan has a question.
I don't have a question for her. I do have a question. Is DJJ here? And
They were here earlier. I'm not sure.
Do they oppose this bill since they alerted this organization?
I don't know. They were here earlier. I'm not sure if they're still here.
Well, if they oppose the bill, where are they?
Well, I can't speak to them opposing the bill because they don't regulate us, but I can tell you that it is of concern for them.
Creditors bar just came in. Maybe they oppose it.
And then if you do that to us, what are you going to do to your local facilities? There are 12 more that are run locally.
Okay, thanks.
Thank you.
Okay.
Well, I'm confident.
All right, Senator Suderline.
Well, I feel like there's so many resources. You know, I put my name on the bill. I hid it on the internet for a few weeks.
Is your name and phone number on the internet?
It is on the same place that the
chair,
bill's
Senator
posted.
I'm not going to give you the same accommodations I gave Senator Perry.
And
all right, Senator Suderline, any final words you want to say before we figure out what to do with this?
Yeah, if they had an issue with the specific thing with them, I would have been happy to talk with them. That's why there were amendments, because people that talked to me, we took care of their situation with the amendments.
Listen, Senator Suderline, do you think now that they know you exist and you know they exist, and we've made some amendments, do you think it might help if you go over in a corner for a little while and talk, or do you think that's going to solve our problem? Or
I'm happy to talk to them, but I think it's pretty straightforward. They said that they had a diversity of folks on there. They'd be fine with this.
Okay. Senator Boysko has a question.
Under the law.
Well, maybe Senator Stewart does too.
Mr.
Senator
Chair.
Boysko first and
Thank
Stewart.
you. Mr. Chair, I'm wondering if he is aware that the Tidewater Youth Services Commission, the Rappahannock Juvenile Center, the Middle Peninsula Juvenile, Arlington, Middle Peninsula, Merrimack, Frederick County, Franklin County, they all said that they oppose it. So I don't know if they didn't talk to you, but they did come talk to me. And they don't love your bill.
Okay. I'm not sure that was a question.
Mr. Chairman.
Senator Stewart has something he would say.
Mr.
Move to report.
Second.
Wait a minute. Senator Stewart, do you want to say something? Senator Stewart, what do you want to say?
Mr. Chairman, I appreciate what the gentleman's trying to do and work on this area, and maybe he just needs a little more time, like a year. I don't know if that's a friendly motion or not, but maybe we want to carry it over for the year and let him work this out with these folks and see if he can come up with a better bill. I don't think it's in very good shape right now, Senator.
Okay.
He's close.
I think we should just take a vote now. I would much rather have that.
All right.
Instead of,
It's been moved and seconded. We carry the bill over. Senator Line,
No.
All right, he doesn't like that. So it's been moved and seconded. Any further discussion about the motion? Huh?
Why would
it's moved to carry over?
We're waiting
for
here
years,
4
the motion.
hours?
Okay,
They
clerk
could
will
have
open the
talked to
roll.
me. We could easily amend.
Okay, hold on. We got an alternative motion. Yeah,
Chair,
Senator
I've
Gates.
got an alternative motion that we pass the bill by indefinitely.
You either like it or you don't.
Okay, it's been moved and seconded. We pass the bill by indefinitely. It's an alternative motion. Takes precedence. No further discussion. Clerk will open the roll. No roll. This needs some work.
Ayes 9, no 6.
All right. Your PBI, Senator Suderline.
Thank you.
Yeah.
I look forward to a similar experience in the future, and being able to have such an opportunity.
All right. Okay, now, we have, I think, seven or eight left. And I think Carol Foy was on deck before we went down the rabbit hole. So, Carol Foy, you've got 144?
Yes, Mr. Chairman. Senate Bill 144, preliminary hearing required, felony charges. Before I begin, I have an amendment in the nature of a substitute.
Okay, Senator Deeds moves, Senator Boyce goes seconds. The amendment in the nature of substitute. All those in favor say aye. Anybody opposed, no. Okay, this sub is before us.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, Virginia Code 19.2-218 makes it very clear that everyone arrested on a warrant for a felony offense has a right to a preliminary hearing. Specifically, it says, quote, no person who is arrested on a charge of felony shall be denied a preliminary hearing upon the question of whether there is reasonable ground to believe that he committed the offense, unquote. However, there is a loophole that has rendered that right meaningless. A prosecutor can simply drop a case in the district court, then recharge in circuit court, where there is no mechanism for conducting a preliminary hearing. The Supreme Court of Virginia has stated that prosecutors have nearly unfettered discretion to dismiss cases without prejudice, otherwise known as no pros. And prosecutors can allow someone to be arrested on a warrant, keep them in jail until their preliminary hearing date, which can be weeks, if not months, then null pros the case, but reinstate the prosecution in circuit court by direct indictment. Sometimes prosecutors indict the case even before dismissal in the district court to prevent the person from being released. This loophole renders the legislature's intent in creating the right to a preliminary hearing completely meaningless. We need to close the loophole that deprives people of probable cause hearings, and that's what this bill does.
Mr. Chair,
Senator Deeds.
I agree 100% with the bill. What I'm trying to figure out is if the case is referred back to the General District Court, is it for just a discovery hearing, or is it to determine whether there's probable cause? And if the court determines there's not probable cause, what happens to the charge?
Mr. Chair, Senator Deeds, so if the case is direct indicted and then it's sent back down to General District Court and there's a probable cause hearing and the judge determines, General District Court judge determines there's not probable cause, then that typically ends the case. However, the prosecutor can typically still direct indict.
What if they've already
Senator
indicted?
Deeds.
I'm sorry. Yes, I apologize, Mr. Chair. They've already indicted. So there's already pending indictment. The case has gone back to the General District Court for a preliminary hearing.
Mr.
Benjamin
if I
would like
could
to
help.
answer.
Yeah, Mr. Benjamin, you got an idea?
Yes, the way the bill is currently worded, if the indictments were remanded to the district court, the case would be essentially stayed in circuit court. The time would not count for speedy trial. The district court would be required to have a preliminary hearing. After that preliminary hearing, regardless of whether the charge is certified, under the current draft, then the case would be returned to the circuit court for further proceedings. I do have language, if the will of the patron is to provide more specificity as to what would happen at the district court. For example, if the district court then conducted a preliminary hearing, did not find probable cause, then I have language that would end the case then, that I can offer.
I like it.
All right? If you like that, then the amendment would be as follows. Mr. Chairman, at the end of subsection A, insert, no indictment shall be returned in a court of record for any charge for which the district court finds there is no reasonable ground to believe the offense was committed by the accused. One additional amendment would be, the addition would be in subsection D. The replacement language would be, upon a remand to the district court pursuant to subsection C, the district court shall conduct a preliminary hearing on all felony charges for which indictments were returned. Only those charges for which the district court finds there is reasonable ground to believe the offenses were committed by the accused shall be certified and returned to the circuit court for further proceedings. Mr. Chairman, I offer that language because I understood that the intent of the patron was to give some meaning to the preliminary hearing that historically had been ascribed to the grand jury. The grand jury originally was designed as a shield between the accused and law enforcement, but, Mr. Chairman, as you know, grand juries now only receive evidence from the prosecution, and they have no evidence, they cannot receive any evidence from the defense. So in reality, the preliminary hearing is the actual stage at which probable cause can be tested. And that's why I think the patron was interested in that language.
So, Mr. Benjamin, I'm trying to understand. So you're saying that if a district court finds there's no probable cause, the case has to end?
The case ends.
Forever?
Yes.
Mr. Chairman?
What if a witness, is sick?
Well, not forever. I take that back because there's no jeopardy.
Right.
All right? So if additional evidence were discovered, additional witnesses were discovered, Mr. Chairman, then the charges could be brought again.
Okay, the words you used in your amendment didn't say all that. It almost sounded to me like you said case is over, never can come back ever again for any reason. And there's all kinds of reasons that preliminary hearing can go bad. So besides the fact that the evidence wasn't good.
All the language said, Mr. Chairman, was that if the district court, upon remand, one solution, Mr. Chairman, is the preliminary hearing is held in the normal course of business, and then there's an indictment. But if there's a violation of this statute, and there isn't a preliminary hearing on that charge for which you were arrested, then the statute sets up the mechanisms, and one is if an indictment is returned without a preliminary hearing, then the indictments are returned to the district court. If there is no certification, if probable cause isn't found, then the case is not returned to the circuit court. By operation of law, however, the Commonwealth can always recharge because jeopardy has not attached. And
You mean they could, Mr. I'm just trying to understand how you're proposing to do this, because we never let district courts make final decisions in felony cases. That's only something that can happen in a circuit court. So you're just saying that the indictment, whatever, would be dismissed without prejudice?
That is the intent.
Yeah,
That's right.
I didn't hear you say that.
If you like the concept, we can make sure that that's what the bill
This
does.
is kind of important stuff, and I think we probably ought to see the actual words and stuff in writing. So maybe we ought to carry this by to Monday and come back with a tight draft instead of trying to do this on the fly, because this happens a lot, and we got to be very careful where we tread, I think. Okay? We good with that?
Well, we do have witnesses here today that want to speak. They've been here for hours.
Oh, okay.
We have.
We can take their testimony. I'm not sure we have.
Workshopped other bills today for an hour.
Okay,
so.
Senator Carroll, I don't think, at least, I suspect you probably have the votes for the objective. It's probably just the words, although I'm not entirely sure, but who's your witnesses? Poking glass?
We have a witness online.
Oh,
and we have
okay.
a robbery.
All right, why don't we set it for 3 and 3? MJ, why don't we go to the video, I guess?
Andy, you may unmute, and please make sure your camera's on.
The video is not coming up yet.
Okay, clock's running.
I promise my lens cap isn't on. I'm happy to talk if you want me to talk. I think you all want me to.
You've turned into like a black hole, but go ahead. I know who you, Andy Elders, we know who you are. Go ahead, talk.
Okay, so look, the bottom line here.
There you are.
Much better. The bottom line here is that the preliminary hearing is designed to do two things. One is ensure a factual basis for the claim. That is, are we going to be able to produce witnesses? Are the witnesses going to give factually sufficient testimony? And it's also there to make sure that there's a legal sufficiency. That is, if what they're saying is true, does that even constitute a crime? These cases need to be filtered before they go to the circuit court for jury trials, because otherwise the circuit courts find themselves deluged with cases that don't have any actual merit, that shouldn't be trials and should have been screened out. That's why this thing exists in the first place. That's why this statute was created, was to protect the accused from the cost and the burdens of having to prepare for a jury trial, hire a lawyer, take time off of work, go through all the things that you have to do, but also so that the courts are protected from frivolous charges that don't even meet a probable cause standard. But probable cause is not a high standard. It's below preponderance, below the civil preponderance standard. It's less than 50-50. If a case can't make probable cause in the district court, it shouldn't proceed to circuit court. I think the intention of the bill is that the case doesn't proceed unless and until the Commonwealth can make probable cause at a preliminary hearing. The district court doesn't have the power to permanently dispose of a felony case, so it couldn't dismiss it with prejudice. But the idea is if this filter mechanism doesn't exist, it causes problems throughout the system. That's how the system was designed. That's why the statute exists. And we're just trying to give teeth to the statute so that it creates a real right that courts actually have to enforce. Thank you for your time.
Mr. Elders, I had a question for you. So if we do what we're talking about here, which is we say if there's never been a probable cause hearing and the case gets remanded to district court, and if it terminates without prejudice to being reindicted, what's to prevent the Commonwealth attorney from simply just not calling any witnesses in the remanded hearing and just saying, you know, I don't feel like bringing anybody, and then you've had your hearing that nobody appeared at, then they just straight indict anyway?
My understanding of the intent is that the case cannot proceed until they make probable cause in district court. So they would not be allowed to straight indict until they were able to make probable cause in district court.
That's a big shift in our way we do things. Okay.
All it would do is it would enforce the statutory right.
Okay. Anybody else in favor? Anybody else online? Oh, Mr. Pogenglass, our time's pretty much expired. Justice Ford in support? Okay. Is there anybody opposed to the bill? Come on up, 3 minutes.
If there's anyone online that would like to speak in opposition, raise your hand.
Good evening to the chair and members of the committee. I stand here, Megan Clark, Commonwealth's Attorney, Prince Edward County, on behalf of the Virginia Association of Commonwealth's Attorneys, and we do oppose this bill respectfully. We believe that there are multiple stages for a probable cause determination, whether that's with the magistrate or whether that's with the grand jury. What I would like to focus on is the fact that if we are to change the way that things are done, at a minimum, it appears that we would have to have victims of crimes testify twice. And what I'd also like to focus on is that there are times when it is necessary in order to protect victims and in order to protect them from fragile situations and further traumatizing them, where we need to null pros a case. I've had situations where on sex cases we have gotten literally right to the preliminary hearing, and then there has been a suicide attempt. And so we need to look at not only whether or not we have probable cause, but whether or not that victim should be placed in the position of having to testify multiple times in front of a court. Also, there are times when witnesses really are unavailable, and again, it's at the last minute. We don't know that this is going to happen, and so we need to null pros a case because that can prevent multiple continuances on cases. And so if we null pros the case, if a defendant is incarcerated, that defendant can actually then be released and then can still receive credit for time served later on pursuant to 53.1-187. They can receive the credit for the time that they served if we decide to bring that charge back. And so that is another reason for why we believe it is important to be able to have this, this mechanism in place. Another reason is that sometimes we have to take people into immediate custody in order to protect the safety of the community, in order to protect the safety of our victims, and as long as probable cause exists and that arrest is valid and then that warrant is then valid. But then again, it may turn out that we do need to null pros that case due to issues with the case. One example also being that sometimes law enforcement will prematurely take out a case, knowing that they just have to have probable cause. And when the Commonwealth gets that case, the charge has already been taken out. There's no mechanism in place whereby we have to be contacted and have to approve of charges. We also deal with witness safety, harassment, and intimidation. If you have confidential informants and you have individuals who have gotten to them before having to testify, and so we need to have the option of null processing the case and then direct indicting. Thank you.
Thank you. Okay. Okay, anybody else opposed?
You don't need to, Taylor, right? Mr.
Okay.
Chairman?
Yeah, Mr. Benjamin?
After conferring with the patron, because the amended language makes such a monumental sea change in procedure, I think the patron is more interested in the substitute as drafted and presented to the committee. And so the provision we've been talking about is subsection D on the back of the substitute. And it provides that upon a remand to the district court, pursuant to subsection C, the district court shall conduct a preliminary hearing and shall then return the indictment to the circuit court for further proceedings. The question is, what if the Commonwealth simply doesn't bring any witnesses?
Right.
The answer is, at least the defense has the benefit of a hearing at which the defense could subpoena witnesses if they sought to, or a hearing at which the defense could move to suppress and produce witnesses for that purpose. So it at least provides the defense with a hearing in district court if there is something the defense chooses to accomplish, but it doesn't end the case if the court does not certify the case. It still returns to circuit court for further proceedings. So that's the conservative approach that the patron, I think, prefers.
Mr. Chairman?
Boy.
Yes, thank you, Mr. Chairman. After hearing some of the statements, what I want to make very clear is that you have, and I know I'm flanked by Commonwealth attorneys and former Commonwealth attorneys, but to be totally fair and transparent, you have some Commonwealth attorneys who will nefariously null process charges so they can direct indict a client in circuit court, and to me that is an end run around the confrontation clause. Now, I appreciate that people may want to protect their confidential informants, they want to protect their witnesses, but what about protecting the defendant? Right? In this country, we are not guilty until proven innocent. So I want to make sure that the defendant's rights are protected as well. Right? As a public defender, it's my job to ensure that their constitutional rights are protected at all costs by any means. And while I appreciate that there are me and most Commonwealth attorneys who follow the law, do the right thing, and sometimes there will come a time that you need to null process the case in good faith, but I can tell you I've had more run-ins than I would like to recall where I've had a bad offer, my client refused to take it, therefore the Commonwealth attorney dismissed the charges and direct indicted them, doing an end run around the preliminary hearing that is in code. It's so important, right, that it's in our code. It's a statutory right. And not only that, but you are also making an end run around the Constitution because you have the confrontation clause. A defendant has a right to address any person against them because their freedom is about to be taken. So I don't take this very lightly. I'm willing to work as much as possible to get as much peace in the valley. But I want to be very, very clear. We talk, a lot about, the prosecution's case, but what about the defendant's case as well? So I would be open to any amendments, and especially the one that Mr. Benjamin just noted.
Yeah. Senator, I agree with you. There's a problem here that we're trying to figure out. The problem is, what's the solution? I mean, I've had felony cases I represented people on where the Commonwealth just didn't just feel like bringing people to court. They just didn't want to be burdened with it, and so they just dropped the case and straight indicted. It wasn't a retaliation for not taking it off or whatever. They just didn't feel like it. And so I don't know how it works in other circuits, but I've experienced that, and I don't feel like that's fair or right either. The question is, how do you fix it? Senator Stewart has something he wants to say, and I think Senator Obenscheimer has something.
Mr. Chairman, I agree with Senator Carol Foy with much of what she said. As a prosecutor, I love this tool. As a defense attorney, I hate it. I never misused it, though, because I didn't think it was right. And I think most prosecutors remember that their job is to do justice, not get convictions. And so I wonder if we should approach this from a different way, and pretty much prosecutors have a carte blanche right to null pros. And maybe that's where we should look at this, and there are times when they need it legitimately, and we want them to have it, but maybe they should have to make a stronger argument to the court for that, as opposed to just being able to say, I now process and judge grants it. So it's just a suggestion. It may be a better approach. I can't understand this. I can't understand the process. I can't understand the procedure. I'm not sure of all the ramifications of it. And I just wonder if you might attack it from a different angle, is all. I agree with where you're going.
Mr.
Just not sure this is the right
I did
way.
want to say, Mr. Chairman, on line 11, I would suggest amending, striking is and replacing it with was. No person who was arrested.
What difference does that make?
It prevents a null pros being used in the manner in which Senator Stewart suggests. If a person, Mr. Chairman, if a person's case is null pros, then they are no longer arrested, and the indictment can be returned despite there not having been a preliminary hearing. If you want the preliminary hearing, and we're only talking about situations where somebody's arrested on a warrant, if you want a preliminary hearing, then the word was needs to replace is. I'm drawing from case law, Mr. Chairman.
I got it. No, I get it. All right, does anybody want to change is to was?
So moved.
Okay, it's been moved and say we change is to was. Any discussion about that? All those in favor say aye. Aye. Anybody opposed? No. So we have this substitute before us with the only change in it is to was. I think that's where we are right now.
Mr. Chairman, as far as I understand the change, Mr. Chairman.
Senator Perry, go ahead.
As far as I understand the change, what it's trying to do is eliminate direct indictments altogether in the Commonwealth of Virginia. Is that correct, Mr. Benjamin?
Mr. Chairman, no, that's not correct. The Commonwealth can always direct indict. This statute is invoked when somebody is arrested on a warrant.
Okay. Senator Perry, you have another question or no?
Mr. Chairman, I still don't understand what is to was does.
What? I'm sorry, I didn't catch the question.
She doesn't understand why the change was necessary or what it accomplished.
With is, then the Commonwealth is still free to null pros and then indict. If a person has been arrested, that status remains regardless of a null pros.
All right. I'm not sure it'll be interpreted that way in the field. But.
It has been. It's Wright versus Commonwealth 52, Virginia Appeals 690.
Right. Okay. Yeah, now this is it's pretty heavy stuff we're in the middle of right now in terms of what we're trying to modify. And I agree we're trying to fix a problem, but this is a pretty fundamental difference in terms of how we do things now. Not that I agree with how we do things now, but it's a hard problem to solve. Is there any further discussion about this? No? Hold on. Okay, hold on one second. Okay, why don't we take this by to Monday so we can talk about it some more? Because I just think we need to have some more dialogue about exactly how this works.
Can I move to no pros?
Okay, this bill will go by to Monday. So now we have 18 bills Monday instead of 17. Okay. Next up on the docket, where am I? I think, Perry, you had some, right? Or one?
This is the only time it's going to go.
How many left? Still 11?
I think we had 6. What? Okay. Everybody in favor of taking a bye for the day, say aye. Aye. Anybody opposed? No. Okay. What did I do with my piece of paper? Perry, you got 209?
209.
Yeah, I don't know what I did with it.
Is there a substitute?
Okay, just leave it there for a second. Do you have a sub or amendment or anything, Senator Perry?
No.
Okay, committee will turn.
Perfect as written.
I bet. All right, so Senator Perry, why don't you explain what 209 does? I think this is wrongful death and adoption, I think.
Yeah. Yes, Mr. Chairman.
Please help me here.
So what this code section does, this code section is about who can inherit.
Hey.
About
Boys.
this code, this bill is about who can inherit from a wrongful death action. As the code stands now, children who are adopted after a wrongful death action, or who are adopted, cannot inherit from their parents. So if they're adopted by a separate family, I'll tell the members of the court or the committee that.
Oh, okay.
So basically, I think what you're trying to solve is that if somebody's parents are killed in a wrongful death case and they're adopted by a family member, they're excluded from the class of beneficiaries from the wrongful death because of the adoption.
Right.
And you're trying to fix that, right?
Thank you for speaking for me, Senator Serval.
Yeah.
I'll tell the members of the committee that we had a case out in Loudoun where the husband murdered his wife. The kids were adopted by a neighbor, and they were prohibited from inheriting then from their mother's estate. Obviously, father was prohibited by the wrongful by the Slayer statute. So this would permit them to inherit.
Senator Obenchain has a question.
I think Senator Peake has a question.
Peek's down there making noises, yeah. Peek, do you have a question?
Yes, Mr. Chairman. Mr. Chairman, a
Yeah.
question for the patron. So in that case, but the children would still have been able to recover under the wrongful death.
No.
No. Mr. Chairman.
If they're adopted children cannot recover under.
They're adopted by somebody else. They cut off.
Somebody else. Your
Yeah,
children.
Senator, the problem is if they're.
adopt them, your
Yes.
children,
Yeah.
you die.
Try to go through the. Hold on, guys. We can't have a conference trying to go through the chair.
But
Okay, Senator Peake.
the question was, in the hypothetical you get, well, actually the event that you had. So the children were killed by their dad. I mean, the wife was killed by the husband or their father, correct?
Correct.
The children were adopted by someone else. But the children could still recover against the dad.
But,
Why
Mr.
not?
Because they're no longer in the line.
Right.
Why would they not be?
Senator
in
Peake,
yeah,
hold on.
Yeah.
Okay, keep going through the chair, okay? But because
Mr.
that's
Chair,
the law,
yeah.
is the answer. Which is, if that's what this tries to do, is to
Yeah.
make it clear that if you're adopted by somebody else, you are now within the class of beneficiaries. You're not kicked out.
They were in the class when they.
But not when the case was filed. Senator Obenchain? Microphone.
So was this a decision by a circuit court?
By a circuit court.
Did
by
a circuit court
judge.
rule that this is not within the class, that these children were not within the class of beneficiaries under 80153?
Let's see what my notes say here.
Or the Supreme Court?
I don't think it's a case.
I thought she said it was.
Children of the decedent, they recover.
Not after adoption.
So
Children at the time of the death.
There was a case.
Unless a judge.
if you'd like for me to read from my notes, I can. On March 20th, 2014, Michelle Castillo was found dead in the basement of her home in Ashburn, Virginia. Michelle was survived by her husband, Braulio Castillo. And the couple's 5 children, who I will not name, were minors. The last 4 were minors at the time of her death. After investigation, the Loudoun County Sheriff's Office charged Braulio with her murder. Braulio was ultimately found guilty of first-degree murder and received a sentence of life in the Department of Corrections. Braulio appealed such decision, and the appellate court upheld the conviction. Further appeals to the Supreme Court of Virginia and the United States Supreme Court were denied. In the aftermath of their mother's death, the children were placed in the immediate foster care custody of neighbors across the street, who I also will not name, who were close friends of the Castillo family and named as permanent guardians in their estate documents. Those neighbors began to raise the children as their own. The parental rights of Braulio were terminated upon his conviction, and the 4 minor children were placed in the permanent custody of the Loudoun County Department of Family Services with a court-approved goal of adoption. In addition to the criminal proceedings mentioned above, there's also a pending wrongful death case. There's been no judgment rendered in the wrongful death proceeding, as this case is still in the Circuit Court of Loudoun County's dock with little expectation of near-term resolution. The Loudoun County Department of Family Services has tried to arrange for the adoption of these children by the neighbors. However, the Loudoun County Department of Family Services will not be able to authorize such adoption if there are financial impacts to the children that will arise from such adoption. The Loudoun County Department of Family Services is concerned with the adoption of any of these children will result in the loss of the adopted child status as a member of the class of children in the wrongful death case, that the adopted child would not receive any benefit in any amount awarded in such wrongful death case.
Okay. Senator Obenchain, you have a question? Your mic's off again.
The County of Loudoun Department of Family Services petitioned the Circuit Court of Loudoun County for aid and direction as to whether there was an adoption of a child would disqualify such child as a beneficiary or member of the class in the wrongful death case. The Circuit Court of Loudoun County declined to render an advisory opinion and dismissed the petition for aid and direction. To avoid a possible forfeiture of rights and interests by a child being adopted prior to any award in the wrongful death case, and to avoid any loss of inheritance rights by the adopted child in Michelle Castillo's estate, it would be advisable to seek changes in the law under Virginia Code 63.2-1215 and Virginia Code Section 801.
We got it. So Senator Obenchain has a question for you.
Yeah, so I understand what Senator Peake is saying with respect to that situation, but I think the more likely situation is going to be mom and dad are killed in a crash, leave 2 small children. They're adopted by somebody else. Can those children recover from the tortfeasor in connection with the crash?
This change makes clear
after they're adopted.
This change makes clear they can.
I would agree with that. I just, or I think I agree with that, because I read this statute and it made no sense. The bill made no sense to me until you explained the situation. It's almost like you need to say.
Senator Obenchain, I said it was a perfect bill.
Adopted by another or something on line 40.
Do you really need, does that matter if you're adopted after the death?
Doesn't matter. You're clearly not adopted by your parent.
Yeah.
If it's after the death.
And the rights have been terminated.
It may be fine.
Yeah. Okay.
VTLA.
Senator Deeds, is anybody opposed to the bill?
If there's anyone online that would like to speak in opposition, raise your hand.
Second.
Okay, it's been moved and seconded. We report the bill. All those in favor say aye, or record your vote.
Ayes 15, no zero.
Okay, bill report. Senator Perry, you got 398.
Bill 398, I think I do have a substitute. Line amendments? Line amendments.
Hold on.
Yes, Mr. Chair. There are line amendments, and they've already been distributed. Would you like for me to report them, Mr. Chair?
Sure.
Okay. On line 133, introduced after respondent, strike shall, insert may. Line 133, after court, insert in writing. And then those changes are repeated on lines 363, 481, and 265. Okay. And the effect of these is that in a preliminary protective order situation, it won't require the respondent to provide the change of address, and then the remainder requires the change of address to be delivered to the court in writing by the respondent.
It smells like requests that were made by the court, maybe, or Senator, explain the bill. I'm sorry. Well, first of all, Senator Deeds moves, Senator Boyce goes seconds. We adopt the amendments. All those in favor say aye. Aye. Anybody opposed? No. Okay. Senator Perry, why don't you explain what the bill does now?
Sure. The bill does, the bill makes it if you are the respondent on a protective order and you have been served with notice of the protective order, that's what the amendments fix, is that you have.
So you're the alleged abuser.
You're the alleged abuser, you're the respondent on the protective order, and you have been served with properly served with the protective order, then you have an obligation to keep the court apprised of your address, update the court with your address. That's what the bill does.
Okay. Is there anybody opposed to this bill?
Mr. Chairman, first,
Yeah.
if I may, the bill does not provide the time period within which the change of address must be filed with the court.
Right. So in custody cases, you have to notify within, what is it?
Well, I
30
note
days?
that the sex offender registry requirement that a person keep the address updated requires that the change of address be provided within 3 days following the change of address.
Mr. Benjamin, this to me smells more like sort of family law, child custody kind of stuff instead of sex offenses, and that in child custody it's 30 days.
Actually, I think, Mr. Chairman, well, I don't know. My only point was that we need a time period, whether it's 3 days, 30 days.
Mr. Chairman,
Senator Perry.
I think that's right. In custody cases, it's 30 days. I think in sex offenders, it is 3 days. I would suggest 7 days. These protective orders, some of them like a 14-day protective order, right? We're not going to get to 30 days. And it's only if they've been served, Mr. Chairman.
Okay. Does anybody have an objection to 7 days? Doesn't look like it. So Senator Deeds moves, Senator Boyce goes seconds, that we add within 7 days in all the places in the bill where that's needed, okay?
Following his change in residence.
Following the change in residence.
Within 7 days following his change in residence.
Any further discussion about that amendment? Senator McDougal.
Chairman, I don't think that's what it says. Does it say change in residence or change in address?
It says change in address in the...
I don't think that's the same thing.
Mr. Chairman, just elsewhere in the code, we use residence, but if there's a difference, then I have no position on it.
Yeah, I think
there is a difference, and I think Senator McDougal's correct that it ought to say change in residence, because somebody might consider their address to be where they got thrown out of.
My suggestion was residence.
That's a friendly amendment.
Okay, so Senator Deeds moves and Senator Boyce goes seconds that we change it from address to residence in each place, and that we say within 7 days following change of address. Okay?
And residence.
Residence. All those in favor say aye. Aye. Anybody opposed? No. Okay, so now we have an amended bill before us.
Chairman,
Yes, Senator McDougal.
I want to make sure. So now this is for preliminary and permanent.
Yeah.
So,
right.
You could have a preliminary. Well,
Senator, I think part of the problem is that when there's permanent protective orders entered and somebody wants to extend after 2 years, they have problems locating the person because they moved. And so this is to keep the address up to date. I think that's part of the idea.
Mr. Chairman, that was what I guess the permanent one makes total sense to me. The preliminary one, sometimes they're heard in less than 7 days. And my guess is for most cases.
Usually 14. Usually 14.
Well, Mr. Chairman, they have to be heard within 14, but they could be heard in less.
Never seen that. But all right, go ahead.
Y'all have too many judges in Fairfax. You could do it faster. Mr. Chairman, what my question is just logistically, want to make sure we're all on the same page, is that on a preliminary, oftentimes if the person is excluded from their residence under the emergency or the preliminary, just because they're staying somewhere else probably does not mean they've changed their residence. So just
nomads.
Okay, OES looks like she's raring to say something there, back there, Senator Perry.
And Mr. Chair,
behind you.
Question as well.
Okay, well, what's that OES talking? We'll go to Senator Peake. You can move the mic. Go ahead.
Thank you. Okay, thanks. Senator Serval, Senator McDougal, that was why we requested the amendment so that for the preliminary protective order, it would be in May. So that way, for example, if you're going to continue it out with a criminal case, that might be 6 months down the road, and the judge can determine if that's appropriate or not.
Okay, Senator Peake.
Yep. Mr. Chair, what's the penalty if they don't notify the court within 30 days?
Well,
or no, that'd be a Class 1 misdemeanor, wouldn't it?
Mr. Chairman, Senator Peake, first of all, I'm not sure what OES is talking about. That's where we wanted the May. Are you talking about the amendments that we had?
Yes.
Okay. The penalty for not reporting it? It's not the protective order, right? So I don't think it is a class 1 misdemeanor.
Mr. Chairman, there are two possibilities. One is the provision about updating the residence could become one of the conditions that are imposed by the protective order. And so if the respondent failed to update their address, that could be a violation of a condition of the protective order. Approach number one. Approach number two is simply to say that a respondent's failure to update their residence can be punished as contempt of court.
Mr. Chair.
Senator Peake.
I would object to it being number one, because if you violate a protective order, you got an automatic day in jail. So if a guy's moving around from place to place because he's been kicked out of his house, doesn't notify the court, he ought not have to go to jail.
Senator Peake, I think what you're saying is you'd rather be contempt. Okay, Senator Perry, you cool with that?
That's a friendly amendment. Also, as we know, the finance deadline has passed.
So Senator Peake moves and Senator Stanley seconds that we add to the end of the sentence about the move here that violation of failure to update shall be contempt of court. Okay? All those in favor say aye. Aye. Anybody opposed? No. Okay, your second perfect bill has been amended 4 times now.
I didn't claim this one was perfect.
You did not.
I did not.
Okay. Any further question? Any further discussion? Anybody else? You guys are cool over there, domestic violence people yet? Okay. Huh? Yeah, we're about to. Okay. Is there a motion? It's been moved and seconded. We report the bill. Clerk will open the roll. Okay.
It's not a simple bill.
Senator McDougall
Ayes
has
15, no zero.
Thank you, MJ. Senator McDougall has a simple bill. Is that 424? 424, which is a variation of the Stanley bill we saw last year, I think, right? Yep.
Look left again, please.
Mr. Chairman, 424 is a request of my Commonwealth attorney, and I'm going to let her tell you a couple of the situations, but it came really because there had been multiple situations where the magistrate would have somebody come in who'd been charged, not necessarily having received all the information. One of the cases, I believe, was a capias that occurred while other matters were pending, and then they didn't get the information about that in a timely manner to be able to go back to a judicial officer and say, this bail is not appropriate. So I think the staff has some amendments that might help with the notice indication. And I'm going to move those after she reads them.
Have those been distributed?
No.
2 of them have been distributed, and then there's just one additional one that I'll report. But the first amendment.
Hold on. Let me get lined up here. Okay, I have 424's amendments here.
Yes.
So are you going to read the new ones or the old ones first?
I'll just go through the ones that you have before you first. It just would strike the word prior and instead insert either before or simultaneous with such person's grant of bail or release. And
Hold on. Wait a minute, Taylor. Slow down. You wrote line 32, you're striking prior?
Yes.
And then?
And instead of prior, we would insert either before or simultaneous with such person's grant of bail or release. Or that would go after notification. So it would read, without notification, comma, either before or simultaneous with such person's grant of bail or release.
Okay, I got that amendment. What's the next one?
And then the next one would just be to add an additional sentence on line 33 right after filed that would say notice to the attorney for the Commonwealth may be made by facsimile or other electronic means.
Which is what I think Senator Stanley tried to do last year. Is that right, Senator McDougall?
I can't keep up with what Stanley does.
Okay. Well, I think you and I talked about this last week. I was showing you his bill from last year that we PBI'd.
But he put it in another section. It applies at a different time frame.
Okay. So basically, Senator McDougall, what you're trying to do is you're trying to say that somebody can't be given bail unless at the moment they're given bail for these violent offenses, unless at the moment they're given bail, the magistrate faxes something to the...
Or shoots an email.
Or shoots an email to the Commonwealth Attorney that this person just got bail.
Mr. Chairman, I don't know what's like in other jurisdictions, but this is like a bail checklist that'll come. So they just got to stick on the fax machine and send it over. So that's what ultimately comes at the end of the day. This is just letting the Commonwealth know, because if there's somebody who has a violent offense and they make bail and they're gone, then there's no way to get them to come back to put additional conditions on them until the arraignment. So I understand the sensitivity about trying to make sure that people are able to get bail. This allows the Commonwealth, if they want to get in front of a judicial officer, a judge, to try to ask for there to be something different or some additional condition.
Okay. So...
But it doesn't stop the process.
Why don't we set the timer at 3 and 3, bring up your person in favor, and, no, it's not.
If there's anyone online that would like to speak in favor, raise your hand.
This is simple.
Go ahead.
Good evening, Mr. Chair and members of the committee. I appreciate you considering this bill. Really,
I'm sorry, who are you and where are you from?
I'm sorry. Mackenzie Babachenko, Commonwealth Attorney, Hanover County. And
From the Redistricting Commission?
Correct, yes.
Okay, that's how I recognize you. Go ahead.
So back when we had presumptions, and I'm not here to comment on whether those are good, bad, or valuable or whatnot, but back when we had that the first time that a bail determination on one of these violent offenses was made, was going to be in court, the Commonwealth was present, the victim was present, we all gave our input. If we didn't like the decision, there was an opportunity to appeal it. There was a stay, which we don't have now with a magistrate making the decision. And at that time, we would know when we left court what the bond decision was. We could contemporaneously let our victim know or have our advocate reach out to the victim and let them know, hey, this person that you've accused somebody of doing something very violent to you, they've been released back in the community, so now you are on notice about that. So a lot of our victims in some of these cases, especially felony sex offenses, they are waiting on pins and needles for that notification. They want to know what happens at the bond hearing. And hours can feel like days, and so the hours matter. Now what we have, presumptions are gone. A magistrate can make that decision. The Commonwealth's not present. The victim's not present. So we don't generally get notice of that. We can't get a stay. What we can do, though, is if we're given notice when somebody is released back into the community or about to, we can at least attempt to go through the motions of amending bond and get back before a general district court or the juvenile court, so we can let them know if there's wrong information or if there's missing information. So I had a prior occasion where I did not get that opportunity, and the person who had very violent background, violent offenses, it was a direct indictment was returned. So the defense attorney went with that person. We didn't know when it happened. It was a direct indictment and gave all kinds of information. That person got bond, $2,000, secured bond. Ended up getting released. We had no idea what happened. Got to the victim. Victim was no longer cooperative after that. On another occasion where there's that was after we had the 24-hour time frame where we get this bond determination checklist. The magistrate had not given me that notification, but somebody, an irate sergeant down with the magistrate, did call me and said, please do something. The person hasn't made bond yet. Can you do something? So I did get notice at the time that he was about to get bond, and we were able to get before a judge and change that bond determination. So it does make a difference, and it certainly makes a difference to the victims. And we're only asking for this notice on the short list of violent offenses, not the longer list of violent offenses. So it's in the 19.2-270.9.1, I believe is what it is, as opposed to the 17.1-805 list, which is more extensive. So that's what I'm asking for. We're asking just for the notice on the violent offenses, so we have a meaningful opportunity to change the bond, if appropriate, and give proper notice to our victims.
Thanks. Is there anybody online?
Mr. Chair, there's no one online to speak in favor.
Anybody opposed to the bill? Come on up.
If there's anyone online that would like to speak in opposition, raise your hand.
Very briefly, Maisie Osteen, Legal Aid Justice Center. I haven't seen the amendment, and I was really trying to listen there. We are concerned that it would create some unnecessary delays. The staff of the Commonwealth Attorney's Office can already be in contact with the jail, can be in contact with the local regional jail, can also staff the magistrates' hearings if they feel that's necessary. Thank you.
Thank you. Anybody online against?
Mr. Chair, there's no one online to speak
Okay,
against.
thank you. So, Senator, we've been up here talking about it, and I think we'd be more comfortable with the bill instead of it being a prohibition if it just stated upon admitting a person to bail who's charged with one of these offenses, then the magistrate shall notify the Commonwealth attorney by fax or email or whatever. So if you don't word it that way.
So, Mr. Chairman, so if I understand, we're saying, would it still have either before or simultaneous with they shall instead of, that's fine. I mean,
Yeah, Senator, the concern is that if it says you shall not admit him to bail, they can say, oh, my computer didn't work, fax machine didn't work, not admitting him to bail for till something, you tell them my fax machine works or something like that.
Mr. Chairman, I think what we're trying to do is get notice, and I think it's different in different parts of the state. Certainly where I live, we do have a lot of regional jails. Most of the magistrates are not even located in the same jurisdiction where the Commonwealth's attorney is. So with small offices, we've got one Commonwealth, we have a Commonwealth attorney in a jurisdiction that's 86 miles long and that Senator Stewart and I share. And the regional jail is probably a good hour away from where the courthouse is. So it's not possible to man that, but you could get notice. And so this is not going to stop the process.
Okay. Taylor, did you get the words in concept that I verbalized?
Mr. Chair, are you proposing that it be more like a judicial officer shall notify the attorney for the Commonwealth upon admitting a person to bail who's charged with an act of violence?
Yeah.
Do you want a time limit or immediately or any time?
Mr. Chairman,
Senator McDougall had language about.
Can the judicial officer shall notify either before or simultaneous with?
Okay, so keep that language then.
Yeah.
Okay.
You're not okay with that?
Is that? I think that's what we said.
Upon the admission to bail.
Upon admission to bail. Is that right? Okay. So Taylor, you got it in concept? Okay. Is anybody good with that amendment? Yes, no, maybe so. I don't know.
Mr. Chairman, just to remind the
Okay,
committee.
hold on. Let me just get this in posture first. Does somebody want to make that amendment I suggested? Okay, it's been moved and seconded. We make that amendment that Taylor's going to write up for us. All in favor, say aye. Aye. All opposed. Senator McDougall, anything else you want to say?
And Mr. Chairman, just to remind the committee, this is only a limited number of violent felonies that this even applies to. So it's not the majority of, there's the longer list of violent felonies, which includes things like B&E. This is just the most significant ones.
And the governor's not going to amend it to the big list.
I won't accept it if you.
Okay, thanks.
I can make that promise. That's not the goal. The goal is really, there have been a couple cases where not all the information gets provided.
You gave the answer I wanted. Got it. Okay, is there a motion on the bill?
Second.
It's been moved the bill be reported as amended. Any further discussion? Clerk will open the roll.
Still have your
Just abstain then.
Are you?
Senator Bagby for air. Senator Bagby. Ayes 9, no 6, abstentions. I'm sorry. Ayes 9, no 0, abstention 6.
Thank you, Mr. Chairman.
All right. Listen, my class action bill has gone by this is like the fourth hearing I've had, and I've had people waiting to hear it 4 times now. And so I'd like to take up.
Wait a minute, there are other members who have bills besides.
They haven't been on the docket 4 times before, and I got people.
Been dragging people out here every week for 4 weeks.
So let's do Senate Bill 259, and Senator Deeds can take over.
I was going to vote for it.
We adopted a substitute to this bill on Monday, so that's, turn your attention to the substitute for 259. And turn your attention to Senator Surville.
Okay, this is a new version of something that the committee has heard before and that's passed, I think, twice out of here before. But I did it a little different way this time. So Just to remind everybody, Virginia is one of only 2 states in America where class actions lawsuits are not authorized in state court. Us in Mississippi, that's it. Because of that, whenever there's a class that's filed and the corporation's headquartered in Virginia, that means the Virginians can't be a member of the class, and so you have to file these individual cases. So like in Herndon, because we have Volkswagen there, they ended up having to we had 300 cases filed in Fairfax County when they recalled some Volkswagens. When the Chinese drywall situation happened, there's a bunch of those. This would fix that. So basically what the bill does this time that's different is instead of amending the existing statute, which has to do with, I think, HOAs and asbestos cases, we created a brand new section that's modeled on Rule 23 of the Federal Rules of Civil Procedure. The only differences between the Federal Rules of Civil Procedure and the statute is, number one, we added some language about joinder to make it clear that how joinder works, because we do joinder in Virginia a little differently. On lines 24 and 25, we made clear you can bring an action for the Virginia Consumer Protection Act under this, because there was some thought that there might be some problems with that. The next thing is we did not use the federal rule on attorney's fees. We just added one sentence on lines 102 and 103 about attorney's fees, which all it says is that attorney's fees are by motion. And then the last thing was we on line 135 and 136, subsection D is a little different. It just says that the court has to create a process if there's money left over at the end, which is a little bit different from how it works in federal court. And then we have a venue statute. Our venue provision, because we can't use the federal venue provisions because we're not talking about venues between states. We're talking about venue within a county. Then we also have this act delayed in effectiveness to January 1 of 2025. That's basically what the bill does. You've seen it before. Happy to answer any questions about how class actions work or why we need it here. But we need one in Virginia. There's a lot of meritorious cases that would promote judicial efficiency and level the playing field for a lot of folks.
Let me ask you, Senator Serval, in states, there are 48 states that have class action. Do we have certain trade-offs? I mean, can you use depositions and summary judgment motions in some of those states the way you can in federal court?
I think Virginia is, it's my understanding that we're the only state in America where you can't use depositions or affidavits for summary judgment in a civil case, not counting divorces. Of course, with Senator McDougal's bill we passed a couple of years ago, we have it now in Virginia when it's a business-on-business case, but I think we're kind of alone on summary judgment.
Is that a trade-off you'd be willing to make for class actions? Is that
it's something that certain stakeholders have raised. I can tell you that it will probably result in my supporters back here vaporizing. But it's been raised with me before, and there's been dialogue about it before. We never had to pass it that way before, but it's been part of the discussion.
Have they also been willing to talk about maybe sweetening that deal a little bit, taking contributory negligence toward comparative fault?
No, I haven't been able to convince them of that either.
They haven't had that.
No.
Okay. Any questions for Senator Serval? Who's going to deliver pizza before long, right? Okay. Well, we have all 3 minutes for people that want to speak in favor of this legislation we've heard before, and 3 minutes for people that are opposed.
If there's anyone online that would like to speak in favor, raise your hand.
Good evening, Mr. Chairman. Mark Dix on behalf of the Virginia Trial Lawyers Association. We support the bill because it promotes judicial economy and efficiency. Thank you.
Thank you, sir. Next.
Hi, good evening. Maisie Osteen, Legal Aid Justice Center. We support this bill as an access to justice.
Thank you.
Legislation. Thank you.
Next.
Evening, Mr. Chairman. Eric Link on behalf of the Virginia Bar Association. We currently have no position on the bill. We just look forward to working with the senator on the bill as it goes forward.
Thank you very much. Is there anyone else? Okay, reset the time. If anybody's opposed to the legislation, come on up.
If there's anyone online that would like to speak in opposition, raise your hand.
And I'm sorry, I forgot to ask. There was nobody online that wanted to speak. Okay.
Hi, Mr. Chairman. Keith Martin with Virginia Chamber. As you know, Virginia has consistently been voted as the best state for business. While there are many metrics that go into that, our legal climate is a big contributor factor of that. As you know, Virginia has a very good legal climate, particularly compared to other states that we compete with for economic development projects. We're concerned that this will upset the balance of our legal system, and particularly, as you mentioned, since we don't have a meaningful summary judgment here, for those reasons, we oppose the bill.
And 48 states have class actions.
Yes, sir, and 49 have summary judgment, too.
Okay, thank you.
Thank you, Mr. Chairman, members of the committee, Matt Burton with Virginia Bankers Association. I think our concern of the significant change of the kind of doing this without, as the chairman mentioned, the broader examination of our civil process, as was mentioned. Again, the last remaining state without meaningful summary judgment, adding to this new civil proceeding could alter the caseload of circuit courts, and the system might not be equipped to handle that. Might mean we need to take a look at the threshold for the filing jurisdictions. Without that larger look at the processes and the procedures in place, we oppose the bill.
Okay, thank you, sir. Next.
Evening, Mr. Chairman, members of the committee, Matt Benedetti representing the Virginia Creditors Bar Association, and we oppose the bill for the reasons stated.
Thank you very much. Is there anyone else? Okay, the bill is before the committee.
Mr. Chair.
Senator Peake.
Yes, Mr.
I
Chair.
apologize. You had done the right thing, and I just wasn't paying attention.
Well, I just did it. You're right, and it's not in front of you. I just understand, appreciate the patrons, what he's trying to do, but we just 2 years ago made jury trials for all criminal cases. So our jury trials in criminal cases in the Commonwealth have risen exponentially. And then we're going to put in class actions without adding summary judgments. I think we need a study from JLARC, someone to check the pressure on our circuit courts, especially. This is probably going to happen more in your busier districts, Fairfax, Alexandria, Arlington, and see when you start getting class actions in these places, when you couple that with the incredible amount of criminal jury trials that they're hit with, and all. Yeah, anyway, that's all.
Mr. Chair.
Thank you. Yes.
I would just note that actually I think in a lot of ways this will reduce the volume, because I said when they had the problem with Volkswagen, we had 300 cases got filed in Fairfax County. When they had the Chinese drywall, I think it was in Newport News or Hampton or somewhere down there, they had like hundreds, if not 1,000 cases that got filed, I thought. And right now, like, for example, if you're a tenant in a building, you got a landlord who's like hurt everybody in the building, they got to file 30 cases instead of one. So I'm not sure it actually works that way. It actually kind of reduces litigation in some ways.
Anybody else have questions for Senator Serval? If not, the bill's before the committee, and we need a motion.
I'll second that.
Okay. Unless there are substitute motions, I'll open the roll, please.
Ayes 9, no 6.
Ayes 9, no 6. The bill reports.
Mr. Chairman, I think I have one other that has Peace in the Valley on it. We can take up real quick while I'm standing here.
Okay, the chairman has exercised his prerogative. He's taken up 502 as well.
Yeah. So this one, I think I have a line amendment.
Okay, has that been distributed, or is that something?
Yes, Mr. Chair, it has been distributed. The line amendment would be on line 345 after the end of the sentence ending with petition. You'd insert a new sentence. If the intake officer refuses to file a petition that a child is in need of services or in need of supervision when such petition is sought by the parent or legal guardian of such child, he shall provide a written explanation that details the reasons for such refusal and shall provide information to such parent or legal guardian regarding any agency other than the court that can provide services for such child.
Does everybody understand the amendment?
I move the amendment.
Okay, motion and a second to adopt the amendment. All in favor, say aye.
Aye.
Okay, Senator Serval, you want to explain your bill?
Sure. So this bill was brought to me by a DV, domestic violence advocate in Fairfax, who actually just put on the bench about a week ago. Basically, she'd seen a rise in parents filing protective order requests against minors in their house, which she thought was a very obtuse way of dealing with that situation. I agreed with. In some states, they prohibit that. So that's what this bill does. It basically says that a parent cannot seek a protective order against a minor in their home. Instead, they have to seek a CHINS petition. And the problem is that in a CHINS petition, the parent can't file it. They have to go to intake and get all that. And so what the language you all just added says that if the CHINS officer refuses to issue the CHINS petition, then the parent can go get the protective order. And that's basically what the bill does, so that we're not using protective orders against minor children, not adults, but minor children who are living in the same residence.
Okay, Senator, you said there was peace in the valley on this bill. Does that the amendment alleviate the problem that was raised by the Poverty Law Center?
I think so. Yeah. Right?
Excuse me. Sushila Varkey with Virginia Poverty Law Center. So I thought that the amendment only addressed CHINs, and those protective order prohibitions are still in the bill.
Oh, maybe I'm right. Yeah.
For
She's
EPO,
right.
PPO, and POs.
She's right.
So I oppose those still, but I'm fine with the amendment that Senator Servell described.
Okay.
Senator Obenshade.
And I didn't listen as carefully to the amendment as I should have, but did that say a child who lives in the home? Because Senator Servell said parents shouldn't be able to file a motion for a protective order against a child living in his home, and that's not what the bill says. I just want to make sure that's what the amendment says.
The amendment, I don't read it as saying the child has to live in the home.
So, Mr. Chairman,
Senator Obenshade,
if a child is not emancipated, is living with his buddies, and is threatening physical harm to the parents, this would prevent them from seeking a protective order.
Right, it was intended about minor children living in the same house.
I don't think it does that.
where does it say that, Senator?
It doesn't say that. I'm reading it now, but that's what was intended.
Okay. Do you want to take this bill by for the day? And
Sure.
Okay, take it. This bill will go by for the day.
Okay, I'll clean it up.
Okay. Do we continue this ordeal? Excuse me? I need a motion to take the bill by for the day.
Second.
Okay. Will all in favor say aye? Aye. Okay, the bill's by for the day. Senator Servell, are we continuing this ordeal or? Yes.
I got an easy one. I got an easy one with witnesses. Do it.
Senator Stewart, what's your bill?
Senate Bill 706.
Senator Stewart says he has an easy bill.
Mr. Chairman, this would expand the eligibility for folks to take advantage of drug court, which I think you just changed the name of it to recovery court. And it mirrors now the federal language. It used to be that if you had any sort of, or the current laws, if you had any sort of violent felony offense, you couldn't participate. This now removes some of those barriers to allow people to participate in drug court. And as I say,
This is Bill 706. There are no amendments or substitute or anything?
there are no amendments. They talked about amendments. We don't need the amendments. I think the bill's in good shape as
Do
it
we
is.
have people here to testify about 706?
Yes. VCJC worked on this bill, and I think
Okay,
they'd like
this
to
is a
speak to it.
VCJC bill.
If there's anyone online that would like to speak in favor,
I don't
raise
think
your hand.
anybody's opposed, Mr.
Prosecutors and defense lawyers are for this bill. Is there anybody opposed to the bill? Senate Bill 706 expands the use of the drug, the drug recovery court.
See, I told the truth.
Okay.
You did.
There's been a motion to report and a second, or unless there are alternative motions, please open the roll. 706 is reported.
Ayes 15, no zero.
Hey, thank you, Senator Deeds. I think Senator Aird wants to try and knock hers out tonight, which is Senate Bill 643.
Thank you.
Is Jordan still here? Where'd she go?
Thank you, Mr. Chair and members of the committee. I do have a substitute to Senate Bill 643. I think that's already been handed out. And, Mr. Chairman, ultimately, this substitute conforms the original bill to a version that's similar to House Bill 1114, Delegate Simon's bill that's making its way here. But ultimately, this bill does a few things. It's about failure to appear. In the legislation, we created a definition of, well, let me explain the substitute. Basically, the substitute eliminates a separate criminal offense of failure to
Hold on,
appear.
why don't we get it in front of us first? So Senator Deeds moves, Senator Boyce goes seconds. The substitute, all those in favor say aye.
Well,
Anybody
given the
opposed?
court, yeah.
No. Okay, substitutes before us.
Well, giving the court sort of a fair tool to continue to ensure court appearance, we tried to hear some of the concerns and make those adjustments. So the bill creates a definition of non-appearance, so that instances when an individual is detained in other jurisdictions, either state, federal, or alternative custody, that wouldn't be included in this definition. It also eliminates a separate criminal offense for failure to appear, both felony and misdemeanor varieties. It would require a hearing to determine whether the individual's non-appearance was willful or not before they are deemed to have failed to appear, which would then be put on their record if determined willful using the procedures laid out in 19-128. So these hearings would be counseled. And if the failure to appear was deemed willful at the show cause hearing, again, conforming to the language of the House bill, the individual can be fined up to $100 or jailed for no more than 2 days. Alternatively, if the individual is currently out on bond, they could have that revoked or adjust the bond terms at that time as well. So multiple tools would, again, remain for remediating what will remain available to judges at this juncture. And so, Mr. Chairman, under current law, people who miss court appearances, even for perfectly understandable reasons, can suffer significant collateral consequences, including new criminal charges. And so our effort with this legislation is ultimately to provide a different mechanism in those instances.
Okay, thank you, Senator. So the bill still basically takes failure to appear from a crime into civil contempt, right?
Correct.
Okay. $100 fine. That's right. Okay. So why don't we? Are there any questions for Senator Aird before we go to support and opposition?
Why would somebody ever show up in court?
Okay.
Mr. Chairman.
Senator McDougal.
So let me ask logistically, if somebody has a felony malicious wounding and they're bonded and they don't show up, how do you get them there if they just decide not to show up?
Senator Aird.
$100.
I would ask, I believe the capias is still issued. Mr. Benjamin, can you confirm?
Okay.
And Mr. Chair.
Ms. May?
If you look on line 64 of the substitute, it says so first of all failure to appear is going to be under 19.2128 under this substitute. And if a person does not appear in court, then the court has to first issue a rule to show cause. And then if the person fails to appear at their show cause hearing, then the court may issue a capias.
Mr. Chairman.
Senator McDougal.
Mr. Chairman, but then for the show cause, so let's say that all that happens and the capias comes, they can be held no more than 2 days and they have to be released because that's the maximum penalty. And then what happens?
Taylor.
I'm looking at line 61 where it says that. If I'm not looking at the right line, tell me.
That's after they're adjudicated.
So you can't hold, Mr. Chairman.
Mr. Chairman, I'm assuming that the
Mr.
bond could be revoked. I don't see anything that alters that procedure. So if somebody doesn't show, once the court gets them in front of them, I am assuming, because I'm just looking through this now, that the bond could be revoked, which would be the logical consequence.
Hold them pending trial. Okay, Senator Obenchain has a question.
What if it's not somebody bonded? What if it's a material witness for the defense?
That's not what this is, I don't think.
Why wouldn't it apply to that? Or a witness?
I think the bill is limited to any person charged with an offense.
Hold on.
Mr. Chairman.
Okay, Mr. Benjamin, you have an answer to that?
I think the bill is limited, Mr. Chairman, to any person charged with an offense.
Okay. Senator Deeds, you have a thought about that?
Mr. Chair, that's exactly right. The statute or the bill says a person charged with a misdemeanor or felony offense, a class 1 misdemeanor or felony. If you look over on line 18,
Okay. Are we all on the same page yet? Yes. Okay, so why don't we set the timer at 3 and 3, take all those in support.
If there's anyone online that would like to speak in favor, raise your hand.
Thank you, Mr. Chair, members of the committee. Dominique Martin with New Virginia Majority, but also speaking in my capacity as a member of the Pretrial Justice Coalition, a coalition of 25 and counting organizations dedicated to pretrial reform, including defense attorneys, bail organizations, community support organizations, data analysts, scholars, and reentry and recovery specialists, and human rights organization, who all agreed that this was it was important to add a process to distinguish between missed court appearances and willful flight, and so we just want to ensure that there's a finding of willfulness prior to the failure to appear going on someone's record and all the collateral consequences that come with that. I know there's a lot of testimony here today, but just to mention that members of the Commonwealth Institute, NAACP, and ACLU might also be here or online or may not be here because of just conflicts in other committees. So that we appreciate the support. Thank you.
Madam Chair, members, Rob Hogenclass from Justice Forward, Virginia. Nothing in the bill.
Madam Chair?
Sorry, Mr. Chair.
All right. Yeah.
Long day. Nothing in the bill prevents a judge from revoking someone's bail. But research shows that while most people who miss court are not dangerous or evading justice, the way courts treat failure to appear suggests that they are. In 2019, more than 28,000 people were charged with failure to appear when their underlying offense was a misdemeanor, and of those, 2,200 people were convicted of failure to appear even though their underlying charge was dropped or dismissed. So this is a large scope problem that we're trying to solve by just getting rid of the underlying crime. It doesn't touch whether someone's bail can be revoked. Thank you.
Thank you, Maisie Osteen, on behalf of the Legal Aid Justice Center. I want to address one specific concern that we heard in the other chamber, and that was the idea that somebody would be released on a very serious crime and then they would be able to outlive the prosecution of their case because they were disappeared. And then prosecutors wouldn't have the tool of a failure to appear to outweigh that they couldn't now prove the underlying case. And we pulled some data from the Sentencing Commission for 2019 and 2020. No one charged with a Class 1 or Class 2 felony, including murder and rape under miscellaneous classifications, because sometimes it doesn't fall under that for data, but we looked at those specifically, was convicted of an FTA and not convicted of the underlying offense. So it's just not a reality that people are somehow outrunning their case. And if it is, that's a very, very small fear that's not supported by the data. Thank you.
Monica Hutchinson with Rise for Youth, also part of the Pretrial Justice Coalition, and we also support this bill. Thank you.
Honorable Chair and Committee. Sheila Williams with No Left Turns, also part of Pretrial Justice Coalition. We support the bill. Thank you.
Mr. Chair, there are 3 people online that would like to speak.
Okay, we have 4 seconds for 3 people online. I think you just need to state who you are, who you're with, and who you support.
Frederica, you may unmute and make sure your camera's on. Please unmute. Guess not. Jessica, you may unmute and speak.
Thank you, Mr. Chair. My name is Jessica Sapolio from James City County. I'm a volunteer and advocate with Pretrial Justice Coalition. We strongly support this because when a failure to appear is listed on someone's record, there's nothing that currently distinguishes a misappearance.
Okay, thank you. We've already exceeded our time for support. We just need to know who you are, who you're with, and you support.
Talia Mallory, Virginia NAACP, and we support.
Thank you. Is that it? Okay. Opposition?
If there's anyone online that would like to speak in opposition, raise your hand.
Mr. Chairman, members of the committee, Jennifer Gilmore, Office of the Executive Secretary with the Supreme Court. Our committees of judges reviewed the bill, and we appreciate very much Senator Aird's working with us to address the judges' concerns. The judges just have one remaining concern, and that's the requirement of issuing the show cause prior to issuing a capias. The judges felt that that decision to issue a show cause or a capias is factually specific and often requires their discretion. At times, there just doesn't make sense to issue a show cause first if there's the defendant does not have a fixed address, or it might be that is the first time that he has failed to appear in this particular case, but has failed to appear multiple times in the past. And I just also wanted to expand a little bit on what Senator Obenshain raised just a moment ago. The proposed change would also alter the penalty for defendants, but a witness would potentially face a harsher sentence, or a harsher penalty than the defendant.
Good evening, Mr. Chair, members of the committee. Megan Clark again on behalf of the Virginia Association of Commonwealth's Attorneys. For the reasons already stated, we do oppose this bill. One of the main reasons is that if a victim or witness fails to appear, they face a harsher punishment than if a defendant fails to appear. The other issue is that if you have a defendant who has absconded, and let's say to another state, and the only mechanism to get that person back is the show cause, well, we have to wait for the show cause to be served out of state, which rarely happens, and then we have to depend on that person to then come back to the Commonwealth to face that charge. And so what we end up having, and someone mentioned a statistic where you have someone convicted of failed to appear, but the underlying charge is dismissed. That happens more often than not because we don't have the witnesses anymore. If someone has absconded for a long period of time, we don't have our witnesses anymore, people move, we just can't locate them, then the only thing we do have is the failure to appear, and so that underlying charge then would go away. And so we do oppose this. Thank you.
Is everybody online? Okay, nobody online. Okay, is there any further discussion about the bill?
Mr. Chairman, can I ask a question?
That's Senator Perry.
Mr. Chairman, Section B, lines 58 through 61, it says, any person charged with any offense or convicted of any offense and for whom execution of sentence is suspended, pursuant to 192319, who willfully fails to appear before any court is required. That's where we get the punishment, right? This is in 19.2.128, or 19.2.128, I think that's right. The penalties for failure to appear?
Penalties 128.
Yeah.
So that's only in cases where the execution of sentence is suspended?
No, Mr. Chairman. It's also where a person has been charged with an offense and has willfully failed to appear.
I see. A and then B, both instances.
Okay, is your question answered, Senator Perry?
Yes. Mr. Chairman, I have another question, though.
Okay, question for who? Go ahead.
My question is, if I think there was a question earlier on about you can only be held for 2 days. Is that right?
I think it's after you've been found guilty of contempt, you can only be sentenced to 2 days. Senator Perry, go ahead.
Which I understand. I guess my question is, someone indicated, well, you can have your bond revoked. The judge can revoke your bond, but that's only after notice, right? And then a hearing. That's at least how we do it in Loudoun.
Senator, I think my impression is the idea is if you had this contempt citation issued, it would then be served on you. You'd be ordered to come on a certain date to show cause why you didn't appear in court. If you did not appear on that date, a capias would be issued, and your bond could be revoked as part of that, I think.
But I think there has to be a hearing, Mr. Chairman, for your bond to be revoked. That's how we do it. We have a bond revocation hearing because then you have counsel present and your counsel can argue, hey, judge, they shouldn't have their bond revoked. They weren't willfully not here. They were actually in the hospital, this, that, and the other.
Senator Deeds has something else to say.
Madam, Mr. Chair, The way it works in the courts where I practice
Man.
is the court.
I think I got a wig on tonight.
I
Twice in one
apologize.
night.
Yeah,
Twice in one
I knew
night.
you're getting a complex about
Twice
this.
in one night.
The court revokes bond, and there is a hearing, but the person gets picked up and is jailed until there's a hearing.
That's correct. That's
Senator
correct.
Perry.
But my question was, there's no reading of the statute where, hey, they've been picked up and now they're being held, but they've been held for 2 days, so now we have to re-release them. I just want to make sure on that.
Mr. Chairman.
Senator Carol Foy, I think. Yeah.
Mr. Chairman, the way I typically remember failure to appear to be addressed is you are held until the bond. However, when you're found guilty, the max sentence you can get is 2 days. There's several different code sections you can be charged when you fail to come to court. And I know one code section says the max that you can serve for failure to appear is 10 days. And so this one changes the 10, I believe, to 2. But you still have to undergo, and you will be held until there's a bond motion, the same way you're picked up on any other charge. And so I believe that there is a way to make this bill more palatable for the people on this dais. I mean, if there is no address to serve the show cause, then it could be a de facto capias that's issued, because it is true. A show cause is pretty much a notification to come to court, but if there's no way to notify them, then it's moot. But if you say if there's no address, or the court may issue a show cause or a capias, then that would address that issue. But the thing that I love most about this bill is that I've had clients who's been sitting in another jail in another county, wasn't transported over for their court date, and was found guilty of a willful failure to appear. And that happens every single day in the Commonwealth of Virginia. Even though they are in the custody of the state and have no authority ability to get themselves to court. It happens where you have clients who are mentally ill or substance abuse addicted, and they're in treatment. They have no way to communicate or contact, and they are found guilty because what the Commonwealth will say is we ask the court to take judicial notice that this client had a court date, was not present, therefore it was willful, and they are found guilty. So I appreciate that the patron has enumerated reasons that a person cannot be found guilty of a willful failure to appear, and these are some of the most notorious reasons for clients being found that. So I do believe that there's adjustments and amendments and line strikes that can happen to get us to a good place, but I think this is a great bill.
Okay. Any other thoughts about the bill? No. Okay, it's been moved and seconded that we report the bill. Clerk will open the roll.
Senator Stewart for.
Okay.
Ayes 9, noes 5.
The report's 9-5. We have 2 left. Subramanian's is not very simple, and Jordan's is a little more simple. You ready to go Mondays? Subramanian, you were good for Monday? Do you still have a witness? They're going to be here anyway Monday, right? Yeah. Okay. All right. The committee will rise.
Senate of Virginia, Richmond, Virginia.